Please, your lordship. My lord, I'm sorry, my lord. My lord, item number 5, my lord. My lord, 12 years. Lordship, matter is old pending matter, lordship. Lordship, I could not fetch out the record, lordship. May I pray to adjourn?
Take the record now. We'll take it as the last item.
Item number 1, 2, and 3.
Hmm.
This matter is supposed to lead by Arbor Pujari. He's suffering for viral fever last for 3
Who?
Arbor Pujari, lordship. The matter will be taken on Tuesday, lordship, if possible.
These matters pertain to what?
Allotment of land. 3 sets of requisitions are there. One is for eviction. Thereafter, they are praying for allotment.
And free is by allotment.
That's it.
Then
Their approach is Honorable Court. Honorable Court has directed to verify the claim of the petitioners. Then thereafter, one judgment is came. Supreme Court has passed an order to clear the vigilance and vigilance. Thereafter, against this order, the state has filed review. 196 there. Review is allowed and directed to rehear the matter, repetition again. That's why this is listed, lordship.
we'll take up the matter. We'll see what is that.
My lord.
Then we'll.
That's it, lordship.
For item number 2. Item number 2.
We'll take up the matter. We'll see.
My lord.
Any more pending? Any more mentioning? No.
I know 1 to 3.
Item number 11. The part had set to talk of this.
11. Part third.
Lord, regarding item number 1 and 2.
We'll take it.
Yes, ma'am.
You see, the top of the list has, but
Yeah.
this is also a top of the list.
My lord.
But it has a more teams out there taking into account that it is part of item number 11 first. Mr. Muzumdar, your matter. Yes, what happened?
I have checked up. There are certain aspects. One is, as your lordship said, Melody, in all cases, the writ court may not exercise their discretion. This is one aspect. There, I would like to argue, my lord. Possibly, there are reasons why I would like to argue that possibly in this case, I'll have to still urge before your lordship that lordship may exercise. Because certain, if I go, so far as suit is concerned, agreement itself is suit is barred. Agreement itself provides suit is barred.
To be?
Suit is barred.
Suit is barred.
The agreement, there is a, I didn't see earlier, my lord, now I have checked. Now, so far as the arbitration is concerned, my lord, I will have two-fold submission. One, if I straightway in the arbitration claim my LD amount, that will be basically a money claim. Then a question of limitation may still come.
It won't come. This court will be exercising the power, take this repetition
My lord,
to be a reference under 21 as regards the dispute.
my lord, they are subject to correction, my lord.
Hmm.
As far as limitation is concerned, if your lordship goes to section 21 and 43, there are limitations of different aspects. One is, my lord, limitation for the purpose of referring to arbitration. They are possibly in this way, this honorable court can take care of it, my lord, in favor of the petition. So far as the claim is concerned, if the claim itself is time barred, then possibly the arbitrator won't be able to pass any award in my favor, because claim, if the claim, like in civil suit, two court says, if your lordship is aware, madam, claim cannot, if the claim itself is time barred, then even the arbitrator will not entertain, and on the ground of limitation, the claim may be kept.
Mr. Mazumdar, just tell me one thing.
My-
There's a dispute between, just take,
My-
for
my-
example, a dispute, which is a reason. There's an arbitration clause. You ask him that, let us appoint an arbitrator. He does not. A section 11 application is filed. Or he will, section 11 application is filed. Then the section 11 application is disposed of after 4 years.
My lord, my lord.
Then what happens?
My lord, possibly, so far as the earlier act is concerned, 1940, section 37(2) possibly will take care of it because it says that moment I make a request, then proceedings will be deemed to have started from that date. So even if the appointment procedure takes a longer time, even then I will not.
I'm not on 40, I'm here.
I'm even under this manner, section 21, 40, if your lordship goes to the provision, subject to correction as far as I have seen. That there is a particular date from which the arbitration proceeding will be deemed to have been commenced. So after that, even if the appointment procedure of the arbitrator takes time, it will not affect me. But for section 21 also, a particular date is there. If my claim has become barred prior to that, possibly that will not.
If it is, if your claim is barred prior to the filing of the writ petition in the
Minor.
instant case, obviously, 43 will take over. But if it is not barred, then in view of the writ petition can be treated for that. And in view of the acceptance by them that there is an arbitration
Yes,
clause,
yes.
why can't this exercise be done under 21?
Well, if it is, then it will be beneficial for the petitioner, but I have got some doubt, my lord. Let us see the provisions.
Limitation, you can do arbitration.
Lordship, may kindly have a look at section 21 parts. ma'am.
When did they deduct the amount?
Uh, while paying the amount, my lord, they have deducted and paid.
When?
That will be in
It was
2011,
first of August 2014.
14 or 11.
Sorry, yes, 14. 1st of August 2014, the final order.
Possibly,
That is
page.
page 62.
The running, internal page.
Internal page is 15 of the affidavit in opposition filed by us. Yes, this one.
No, this
But-
is not the date, my lord. Because in this application, they themselves say that your application for waiver of LD, that means LD has already been deducted. Which was.
No, the decision, if it is taken
My lord. My
by
lord,
the authority,
My lord.
you have made an application.
my lord.
Application meaning thereby you have sought to
Refund, say refund.
not refund, we may say the application was sought for an amicable solution prior to initiating any dispute.
My lord, my lord.
And that has been answered by the order dated 1/8/2014.
14.
Then wouldn't that the limitation be there when you filed the writ petition in 2014?
But that's what I'm saying, my lord. If the arbitration, the terms of arbitration is such that I pray for a declaration that either that this decision is wrong or the, my lord, the,
We may say that the dispute
my lord.
arises out of this.
Then,
The dispute arises out of this because you see-
your lordship is correct, my lord. In this case, considering the facts and circumstances of this case, it will not be a money claim simplicity. Because dispute is elsewhere. Dispute, so far as money is concerned, it is determined amount, it is not, there is nothing to be decided, but the dispute is elsewhere. That way, your lordship may be correct. That dispute may be deemed to have been arisen from this.
Yes,
Because
because
here is the-
to that you tried to amicably settle,
Exactly.
and as such you have requested.
And they have refused to.
They refused it after
Okay.
taking into account the recommendation, although without taking into account the recommendation.
Possibly. If that way, that's why I said, I was also thinking that it will not be a money claim simplicity, even in the arbitration. Because the dispute is elsewhere. Dispute is not that some money I am.
Now, your dispute would be
Yes.
as to whether the recommendations so submitted
Yes, ma'am.
can be construed to be a certification by the engineer in charge for the purpose of section 14, clause 14, and thereby they cannot impose the liquidated damage upon.
Yes.
That is the dispute.
Yes. In other words, or maybe consequentially, that the decision of the EIC. engineering
And the
judge is
consequential
likely-
relief will be for the refund.
Yes. Refund will be a consequential relief. This is what I was
So because you see, the recommendation has been made subsequently.
subsequent.
So when the recommendation has been made, so your issue now is
Yes.
as to whether the recommendation can be construed to be a certification in terms with clause 14,
Yes.
and thereby they cannot impose the liquidated damage,
And such recommendation is final as.
which have been finalized
And
and not taken into account and brought into action or put into action by the communication dated 1/8. That is the only way out.
because why I was saying like this manner. It is well settled that even in arbitration, this limitation will come.
Because it is a question of an interpretation of a term of a contract, which falls absolutely within the domain of the arbitrator.
Some interpretation has become
As to
relevant
whether
now.
it would be a recommendation can be treated as a certification,
Certificate in terms of what
because the recommendation came later on.
came late. So that way there is a need to declare that yes, it is equivalent to a certificate. And this, there are 16 of these judgments. I was just looking into it.
Praveen Enterprise. Yeah.
So, Praveen.
Oh.
I need not read
In fact, this is the only judgment
my,
where you have a very clear-cut aspect on what is a reference.
that part is also there. Because in this case, my lord, even for reference, there are limitations. Those things are also discussed, my lord.
No, for reference, 137 comes in.
137. It has clearly said 137 will come.
137 will come in, but 137 will come in. Now, can we not construe, taking into account that they have raised the issue of arbitration? And I being a judicial authority to the effect.
And 137 was 3 years now. Once it starts from today's your lordship's order. See,
No, the matter has been pending.
yes,
So the moment they say so, this could be exercising not only the powers under, not powers under section 8, but section 11, but powers under section 8 for making a reference.
section 8.
Or even other words, just imagine a situation that in a suit, a section 8 application is pending for
Reference.
10 years. Would it go outside the limitation? No.
And section 8 petition may also remain. Sometimes I have the experience, section 8 application is filed there on the first day as is required, my lord. And then some decision is taken and the agreed party approaches High Court, it remains pending here for 5 years. May happen. Only one, my lord, difficulty of the petitioner would be the value is Noida. The value is Noida.
That I can't touch.
My lord, I'm not on that. I'm not on that. What I'm saying is, my lord, claim is being possibly around 40 to 45 lakhs claim with interest payments slightly. So, pursuing an arbitration proceeding in Noida from here with slightly financially, my
So engage your younger one.
Very interesting. And minus so far as the evidence etc. is concerned, the injury charge is no longer there, it is expired. It's there. So that way I would like to still urge upon your lordship that if the, in the requisition decision is taken,
I can take it up. I have no problem, but I will dismiss it. That is what I made it very clear.
because
I
my,
can't
my.
approve it.
submission
Moment
is-
you say that,
Madam.
I will decide on the question as regards that it can't be a certification because the certification happens at the time when you file the application within that period. Nothing has been brought on record and accordingly, the recommendation cannot be treated to be a certification which happened pursuant to the imposition of the liquidated damages.
Madam,
On that, I can put it immediately and dismiss it.
madam,
I'm only seeing your face out here saying that, okay, let us give
Madam,
something more than that.
that aspect is there. Well, what I'm saying is, my lord, true, my lord, it has been just the reverse. While the LD should have been done prior to settlement of the deal, it has been done subsequently. But otherwise, my lord, there, in my humble submission, there has been a substantial compliance because the procedure prescribes that the whole issue as to whether I was prevented by sufficient cause or I was prevented by causes beyond my control.
How can I look into that?
No, I'm not saying that. Well, I'm not.
No, Mr. Majumdar, just without that recommendation being made by the engineer in charge, you satisfy me that this court should interfere, taking into account those facts and say that yes, the imposition of liquidated damage is wrong. That is another aspect of the matter which this court can very well decide.
Well,
But
I-
satisfy me on
No,
that.
I'm not praying before your lordship that this court should adjudicate that aspect. What I'm saying is, my lord, ultimately, it is the recommendation or certificate issued by the injury in charge, which is the requirement under the agreement.
They are saying that it is not a certification.
No, they are not saying. My lord, their stand is very clear. What they are saying is that in spite of clause 14, the competent authority to issue such certificate is the higher authority above the injury in charge. This is their specific stand. ma'am.
No, I'm sorry to interrupt. That is also hedged by the submission that these
On behalf of.
engineer in charge has not issued any certificate at all.
That is there.
Yes.
So thereby they are
He has
saying
not
that
issued
there
any
is no
certificate at all.
certification.
That's why, my lord, he has.
The certification has to happen prior to the imposition of liquidated damage.
Yes.
What you need to do is if the moment, because if you see various contracts out there, if you have any problem out there, you need to inform the engineer in charge. Look here, this is the problem. And the engineer in charge has to then certify to that effect that, look, this is the problem and as such, this is it. And that gives you the right to hold that certificate. And in case they initiate any proceeding for liquidated, that would be a certificate not to do so.
That way, it's correct that it has been prior to the settlement of the bill. That I agree because the terms of the agreement is very clear. It says prior and I will not pay, I will not have to pay. And here they will be deducted and I have proceeded thereafter. That way, madam, I agree.
Which one?
No way but to go for arbitration. ma'am.
That is the only way, because that is the only way you can save yourself and say something in before the arbitrator and explain it. Now, have you agreed to a mutual arbitrage?
You know, that part possibly we'll have to, lordship will pass some order and we'll leave it to the parties and on the next day, man, will come up because unless some.
No,
official
that
order
I
is
can't do that. Although I can leave it to the, I may say in view of Praveen and I'm making a reference, leaving the parties to do whatever they like.
No, but.
Now, if I do that,
Madam.
you have a big problem again later on. Then you can't, if he does not go for any arbitrator, is not, because he has already appropriated the money. If he does not go for, you have to move a section 11. Now, section 11 moving out there you have a problem.
Then, we'll have to again
No, it affects yes.
interact.
Because if you mutually agree, then this particular jurisdiction aspect cannot be challenged by them at a later stage.
But so far as.
Lordship is binding us with from
No,
all
so-
angles.
No, that is, I have no problem.
Fine.
But this is going to help you out
Fine.
if you mutually agree.
Fine.
If you don't agree, that is the business.
My learned friend's client cannot say that your lottery is binding because they themselves have submitted.
No. The moment this, you have a consensus.
My lord, I'm not on this, what I, my learned.
No, I'm saying if you have a consensus of the mutual arbitrator out there, then it becomes binding on both the parties
Yes.
out there,
And we go to the
not
next
to
step
challenge the jurisdiction on the question of limitation.
before the arbitrator. Before the arbitrator again. That can be done. Huh? And so far as, at the level of lawyers, it's no there is no difficulty, but then so far his client is concerned with some sort of an order, some indication. So that before entering.
No, you just think about another aspect. You see, if you see in Praveen Enterprise, paragraph number 13,
Fine.
you see this. And
My lord,
reference to arbitration
can be.
can be in respect of the reference of dispute between the parties to the arbitration or may simply mean referring the party to arbitration. Section 8 of the Act is an example of referring the parties to arbitration. While Section 11 contemplates appointment of an arbitrator, so and so, appointment. Section 8 does not provide for appointment of an arbitrator, not referring of any dispute to arbitration, but merely requires the judicial authority before whom an action is brought in a matter in regard to whom there is an arbitrator to refer the party. When the judicial authority finds that the subject matter of the suit is covered by a valid arbitration agreement between the parties to the suit, it will refer the parties to arbitration by refusing to decide the action brought before it and leaving to the parties to have recourse to the remedies by arbitration. When such an order is made, parties may either agree upon an arbitrator and refer the disputes to him, or failing which shall file. Now, would this order, if I now refer it to the arbitration, would give you a cause of action for the purpose of filing a section 11? That is what I'm saying. In view of this, and thereby the limitation is taken care of.
Meanwhile, Dr. May kindly have a look at the arbitration
The
clause.
only,
Arbitration clause is, okay, so this provides for an appointment procedure. Also.
what procedure?
Appointment procedure.
Now, understood. There's no quarrel with that.
Right.
The appointment procedure is this: when such an order is made,
Right.
parties may either agree upon an arbitrator and refer the dispute to the parties, which is the appointment procedure.
Right.
Or failing an agreement, so that procedure is gone, file an application under section, then it will be under 11.6, you have to file an application. Now, would this order by which this court says that I'm not and referring the parties to arbitration in terms with section 8 would give you a cause of action for the purpose of moving an application for appointment of an arbitrator
Straightway.
without a problem with the limitation? That is the only worry.
The lordship passes their kind of order and stops there. Possibly again, parties will have to refer to the various.
Clauses of the agreement.
Yes.
And after that,
Then-
if it does not, then you have to
Then-
move
yes.
under 11.6.
Yes, yes.
Now, would it foreclose in view of the delay or no? Or would my order be, the order would be a cause of action for the purpose of filing that section 11? And if that be so, that limitation under 137 is duly taken care of. I think that can be done.
I think, my lord, the better course would be if it is left to the parties to choose an arbitrator, keeping the matter pending.
No, that I won't do that. That, you see, this matter has to finish today. Today is the last day.
Yes.
So it can't go beyond that. So I do one thing, I will appoint, and then the course of action will be there. I'll point out this particular paragraph out there and put it, then you do it. The parties will be at liberty to take action. And this will give you a cause of action for filing under
Section 11.
section 11 if it is
If,
not
if,
done.
if their procedure fails.
Procedure is not done.
All right.
think that is the best.
Sure.
The petitioner herein
Lordship will give it.
Yes. The petitioners herein. No, the petitioners herein have filed the instant writ petition challenging the action of the respondent authorities in not releasing the 10% liquidated damages, the 10% not releasing.
My lord, may not indicate the percentage because in one case it is 8.5%. There were three contracts. In
Right.
one case, it is 8.5%.
The petitioners herein have assailed the actions of, has filed the instant writ petition, assailing the actions of the respondent authorities in imposing liquidated damages upon them, which as per the petitioner is contrary to clause 14
Yes.
of the, what is that? Of the special conditions of the contract
Yes.
entered into by and between the petitioner, number one, and respondent number two. Who's next? The cases of the petitioners herein that the petitioner was issued a letter of acceptance for construction and supply of floating steel pontoons, PONTOONS, for NW2 by the communication dated 9/7/2008. The period of the contract, as per the letter of acceptance, was 7 months from the date of issuance of the work order, and as per the agreed terms and conditions. The petitioner number one was requested to deposit the performance security of 5% of the contract price, that is rupees 7,48,800, as per clause 33 of the instruction to bidders of the tender document, and to attend the office to sign the formal agreement within 15 days from the issuance of the said letter. These are two letters of acceptance, na?
See, there would be three, but they have enclosed only two at annexure 5 and 6. So this amount of 5% will also be different. In the 7, it will be 748,800 and
How many tenders were issued?
3. So
Three tenders.
3.
And they've enclosed only one tender.
Only 2.
No, tender is only one.
The agreement is only one.
One agreement for 3 works.
No. 3 separate agreements, but they have enclosed only one.
Which are the works, Mr. Dr. Kindly see annexure 1, page 18.
Annexure 1, page 18, it will be serial number 5,
and 6.
5 and 6, and there will be one for Tezpur. Here, Nimati and Dibrugarh are finding mention. There will be one for Tezpur.
Tezpur, they have not mentioned anything. I think they are not asking for Tezpur, letter of acceptance they have enclosed.
Yes. Three contracts for Tezpur, Nimati, and Dibrugarh.
So there will be 3 arbitrations.
3 arbitrations.
And for each arbitrator, how much amount has been deducted from you?
According to them, it will be around 50 lakhs
In 3
in 3.
combined.
3.
So there has to be 3 arbitrations. It can't be 1.
No. Your Lordship can kindly come to page 36. The name of the work and contracts, these are indicated. Two pontoons at Tezpur, 2 at Nimati, 2 at Dibrugarh.
And have you indicated anywhere how much you have deducted?
Yes, in page 62, running page 62, at clause 4. For Tezpur, 12,72,000. And for Dibrugarh and Nimati, 17,77,000 and all.
So total 46 lakhs.
Yes.
It was line to be like Arambok. The instant petition has been filed by the petitioners, challenging the imposition of liquidated damages upon the petitioner in respect to 3 contracts. The facts involved in the instant case is that the Inland Water Authority of India had, in pursuance to notice inviting tenders and finding the petitioner's bid to be the lowest, na? Lowest, awarded 3 contracts to the petitioner by issuance of letter of acceptance as well as the work order. The said contracts in question are: number 1, construction and supply of 2 pontoons for Tezpur, Tejpur, of an amount of rupees, of the bid value of rupees 1,49,76,000, on which, in respect to which, a letter of acceptance was issued on 27/2/2008. Number 2, construction and supply of 2 pontoons for Nimati of the bid value of rupees 1,67,70,000, in respect of which the work order was issued on 9/7/2008. And number 3, construction and supply of 2 pontoons for Dibrugarh of the bid value of rupees 1,67,70,000, in respect to which a work order was issued on 9/7/2008. It further appears from the letter of acceptance so issued that the time was the essence of the contract, and the delivery period of the two pontoons was to be completed within 7 months from the date of issuance of the work order as per the agreed terms and conditions. It is further relevant to take note of that pursuant to the issuance of the letter of acceptance as well as the work order, the petitioner petitioner number 1 entered into separate agreements in respect to the 3 works with the respondent number 2. Where is that agreement? You have a copy of it? Someone? Still no yet.
Last day I produced my lord. They have,
Where is it? It returned.
no, but it was given back to us.
I've given it back.
He is given back to us, but the parties took it away.
Hey, you have it? Any of the agreements? Give it to me. Separate, 3 separate agreements are entered in. Although in the writ petition, only the agreement pertaining to the construction and supply of 2 pontoons for Niyamati, Neamati, has been enclosed as Annexure 3 to the writ petition. But during the course of the hearing, the learned counsels have produced before this court the said agreements. From a perusal of the said agreements, which are parametry in content as regards the terms and conditions, it has been stipulated that various documents shall form and has to be read and construed as the part of the agreement. The various documents were A, agreement, B, notice inviting tender, C, instruction to bidders, D, general conditions of the contract, E, special conditions of the contract, F, technical specifications and drawing, G, form of bid, H, cost schedule, I, letter of acceptance. It further reveals from the record that the contracts in question could not be completed within time. In respect to the contract pertaining to the construction and supply of two pontoons for Tejpur, which is the contract for yard number 101-102. There was a delay of 117 days, bracket 17 weeks. In respect to the contract pertaining to the construction and supply of two pontoons for Nimati, that is the contract for yard number 105-106. There was a delay of 164 days, bracket 24 weeks. And in respect to the construction and supply of two pontoons for Dibrugarh, that is the contract pertaining to the contract for yard number 103-104. There was a delay of 206 days, bracket 30 weeks. Subsequent to the completion of the said contracts, the final bills of the petitioners were released after deducting 10% of the total value of each contract.
Up to 10%. In two cases, 10%, in other one, less than 10%. In one case, less than 10%. So Lord may say up to 10%.
No. They themselves say at page 36, they have deducted 10. Later on, it became different. Page 36, if you see. Final bills of all the three contracts have been released and 10% of the total value of each contract was deducted as compensation for delay in sale. So they themselves admit. Deduction of 10% of the total value of each contract. In terms with clause 14 of the special conditions of the contract. Under such circumstances, the petitioner submitted a representation dated 7/4/2011 requesting for release of the amount so deducted against liquidated damages. In pursuance to the said representation dated 25/4/2011, the respondent number 2 issued a communication dated 25/4/2011 to provide adequate documentary proof to substantiate delay and establish that the same was beyond their control. Thereupon, the petitioner submitted some documents and details. By the communication dated 19/7/2011. It is, however, relevant to take note of that such documents do not form a part of the records. Next. Upon the said documents being submitted, the deputy director of the respondent number 2 authority issued a communication to the director of the respondent number 2 authority, who was also the engineer in charge, by the communication dated 4/8/2011. The director of the respondent number 2, by the communication dated 1/12/2011,
Director was the engineering charge.
I have mentioned. The director. Who was also the engineer in charge. Communicated here by the communication dated 4/8/2011. The director of the respondent number 2 issued a communication on 1/12/2011 stating inter alia that the Guwahati office of the respondent number 2 had calculated the delays which had occurred due to construction of floating steel pontoons due to reasons beyond the control of the contractor. It was further mentioned that severe delays had occurred due to delay of IRS inspection of the pontoons at different stages of the construction. To the said communication, the detailed calculation of the delays attributed due to late inspection by the IRS, procurement of imported anchors, etc., was enclosed in the tabular form. It further appears that thereafter, There was further inquiries being carried out by the respondent number 2 authority. It further appears from the records, the authority. And what transpired in the meantime is, however, not known from the records. Be that as it may, on 25/4/2013, the Assistant Director of the Respondent number 2 again issued another communication to the Director of the Respondent number 2. Requesting to furnish definite recommendations on the delay caused on account of inspection by the IRS, launching of pontoon and supply of anchors, etc., to consider the waiver of the liquidated damages deducted. Pursuant to the said communication, the Director of the Respondent number 2 issued a communication to the Chief Engineer Civil of the Respondent number 2. Wherein it was mentioned that as per the contract agreement for all three projects, bracket yard number 101-106, bracket close, the Director of the Respondent number 2 as EIC was recommending the waiver of the LD based on the statement submitted by the contractor for reasons stated to be beyond the control of the contractor. The petitioner, on coming to learn about the said communication dated 17/6/2013, issued a communication to the Chief Engineer Civil of the Respondent number 2, dated 25/6/2013, for release of the said amount so deducted, in view of the recommendation made by the Director of the Respondent number 2. It further appears that as the respondent authorities did not take any steps in that regard, a reminder was issued on 7/10/2013. Followed by another communication dated 9/1/2014. The petitioner, therefore, on account of the non-renewal of the non-payment of the deducted liquidated damages, in spite of the recommendation being given by the engineer in charge, the petitioner, being aggrieved, has approached this court under Article 226 of the Constitution. It appears from the records that the respondent number 2 to 7 have jointly filed a have filed an affidavit in opposition dated 5/8/2014. In the said affidavit in opposition, it was mentioned that in respect to the contract for yard number 101-102, which pertain to construction of two construction and supply of two pontoons at Tejpur. In the said affidavit in opposition, it has been mentioned that the delay caused by the petitioner was much more than was taken into consideration for the purpose of imposition of the liquidated damages. In that regard, a chart has been also mentioned at paragraph number 4 of the said affidavit in opposition, which for the sake of convenience is quoted hereunder. Today, page 49, running page 49, page 2, এখন chart এখন আছে। It was further mentioned that pursuant to the deductions so made on account of liquidated damages while releasing the final bills, the petitioner preferred an appeal before the respondent number 2, giving reasons for the delay. The competent authority duly examined the case and had decided to levy liquidated damages upon the petitioner. On account of there being a delay of more than 20 weeks in respect to two contracts and 17 weeks in one contract. It was further mentioned that the said aspect of the matter was also duly intimated to the petitioner by the letter dated 1/8/2014. Footstep. In the said affidavit in opposition, it is pertinent at this stage to take note of that the said affidavit in opposition, a specific and categorical stand was taken that the contract agreement, in the contract agreement, there is a specific clause for arbitration. And as such, the writ petition was not maintainable. It was further mentioned that as an effective, as an adequate and efficacious remedy by way of arbitration has already been had already been agreed to by the parties at the time of entering into the agreements. And as the issue involved herein would entail adjudication of disputed questions of facts, the writ petition, therefore, ought not to be entertained. It further transpires that without prejudice to the said contention, that the writ petition ought to be dismissed on the ground of availability of an alternative remedy, that is the arbitration clause. It was also the specific stand on merits that the recommendations so given by the engineer in charge cannot be construed to be a certificate in terms with clause 14 of the special clauses of the contract, special conditions of the contract. Where is that? Mr. Datta, where is that?
Clause 14, they have,
No, you have stated in your affidavit, na? A specific stand.
oh,
It is not a certificate.
oh, that is in the additional affidavit that we have filed.
এখন additional affidavit আছে তো বছর। Yeah. You filed how many additional affidavits?
Only one supplementary,
No,
affidavit, page 104.
No. You have filed another additional affidavit. It seems you are a new like Mr. Mozumdar. Another additional affidavit filed on 21/2015.
So this was latest, Milord. It was on 1st of August 2023, page 104.
I think.
And 105, your lordship will find.
এখন supplementary agreement.
Yes, supplementary
It
affidavit,
is not additional, supplement.
page 105. First line from the top. Moreover, the engineer in charge has never conveyed his recommendation or certification for waiver of LD.
এটা নেই। अब also কি লিখলে তো? Specific stand and the without prejudice to the said without prejudice to the maintainability of the writ petition on the ground of availability of a adequate and efficacious remedy. The petition, the respondent number 2 to 7 have also refuted the case of the petitioner on merits. It is further seen that pursuant to the filing of the affidavit in opposition, the respondent number 2 to 7 had also filed an additional affidavit. On 21/2015 and another supplementary affidavit on 1/8/2023. Next. Although there are various aspects of the matters, the respondent number 2 to 7 have refuted the claim of the petitioner. But this court finds it relevant to take note of. But this court, taking into account the order which this court proposes to pass, finds it relevant to take note of the specific stand of the respondent number 2 to 7, as stated in their supplementary affidavit, that the engineer in charge had never conveyed his recommendation or certification for the waiver of the LD to the petitioner, as have been sought to be projected by the petitioner. It was further mentioned that the engineer in charge is only a supervisory officer under the authority and does not enjoy any supervening power independent of the authority. Further to that, it was mentioned that the key operative provision of clause 14, inverted comma, engineer in charge on behalf of the authority, inverted comma, means engineer in charge is authorized to certify in writing of the waiver of liquidated damages only after the approval of the competent authority. It was therefore the specific stand of the respondent authorities that the engineer in charge could have certified the claim of the petitioner firm only on behalf of the authority, that is the chairman IWAI, who was a signatory to the agreement. It was further mentioned that the interdepartmental communications that are made, comma, aids in the process of consideration for the appropriate decision-making process, but not the decision itself, and hence cannot be relied upon as a basis to assert any claim therefrom. Further to that, it has been mentioned that the letters dated 1/2/2011 and 17/6/2013 were mere interdepartmental correspondences between officers concerned in connection to the contract work. And the petitioner's assertion of his claim for waiver of 10% LD on the basis of that said interdepartmental communications are not as per law, for which the petition should be dismissed. Next. This court further finds it relevant to take note of that in the said that take note of that the special conditions of the contract, this is where Arbitration 21 is where?
20 special conditions of contract.
Are you sure?
Yes. Sorry, my lord, general conditions of contract.
Right.
It has to be general, can't be special.
General condition.
Right hand side, I have given the flag mark, right hand side. On top. Flag outside.
কি লিখলে? That finds it relevant to take note of. No. Next, Vibhuti. Before further proceeding, this court further finds it relevant, taking into account clause 3 of the agreements entered into between the petitioner with the respondent number 2. Wherein it has been stated that the general conditions of the contract shall form a part and parcel of the agreement. In the general conditions of the contract, now clause 21 of the general conditions of the contract stipulates arbitration. The said contract clause is quoted hereunder. Today. We are taking this for the time being. You did not.
It is
He-
also quoted in my supplementary affidavit. Page
Ah,
109.
Yours, what you have done is, it seems, it is okay, here it is given.
Page 109.
109.
Not very
Okay,
legible,
okay.
not to be used by one, not very legible.
It's an interesting matter, 2014. I have, otherwise, if it was a 2021, I would have dismissed your petition on the face of it. You are asking for 3 agreements are not there. You have only issued only 1 agreement. Sevi, is it something environmental friendly you have done? Huh?
My difficulties
Not
I
to-
have come subsequently.
Something like on
Even.
going green or something to that effect.
Not only that, my your lordship has made an observation, some reports are not there, some letters are.
I'm making that observation because obviously, because what has happened is that you have only 1 agreement. 2 letter of acceptance, although there are 3 contracts. It's close to quote for you. It's page 109, 110 পাবো, কিন্তু এখনতো আছে দেই। From the above quoted clause, more particularly clause number 21.1, it has been stipulated as to what contracts, what questions can be, what disputes can be referred to arbitration. From a perusal of the said, Mr. D. Mujumdar, the learned senior counsel appearing on behalf of the petitioner, though submits that the imposition of the liquidated damage have already attained finality. And as such, the arbitration clause cannot be an adequate and effective relief remedy. This submission, however, have been refuted by Mr. S. Dr. the learned senior counsel appearing for the respondent number 2 to 7. A perusal of clause 21.1 stipulates that except as otherwise provided, all questions, disputes or differences in respect of which the decision has not been final and conclusive arising between the contractor and the authority in relating to or in connection with the contract shall be referred for arbitration in the manner provided under and the sole arbitrator appointed as follows. And the sole arbitrator to be appointed as stipulated in subclauses Roman 1 small, Roman 2 small, Roman 3 small. The use of the word final and conclusive would only arise now, would mean and has to be construed as such questions, disputes, or difference which have attained finality on account of acceptance of the decision or have been made final on the basis of the terms and conditions agreed upon by the parties. In the opinion of this court, the imposition of the liquidated damages the decision as regards the imposition of liquidated damages was taken on 1/8/2014. Even prior to the 14 and that is much after the filing of the writ petition. The petitioner, however, the continuation of the litigation in the instant proceedings by way of the instant proceedings pursuant to the order dated 1/8/2014 further shows that the petitioner have not accepted the order dated 1/8/2014. And as such, the dispute as to whether the imposition of liquidated damages upon the petitioner in respect to the three contracts in question was as per the terms and conditions of the contract continues to be alive. And as such, it cannot be said. And as such, the submission so made by Mr. D. Mojumdar, the learned senior counsel, to the effect that the arbitration clause cannot be made applicable in the opinion of this court is misconceived. Next. This court further finds it relevant to take note of that from the respective stands taken by both the parties, the question which arises, the dispute which arises is as regards the interpretation of clause 14 of the standard terms of the
Conditions.
standard conditions of the contract, which empowers the respondent number 2 to impose liquidated damages on fulfilling certain conditions stipulated therein. Mr. D. Mujumdar, the learned counsel, senior counsel appearing on behalf of the petitioner, submits that the recommendations so given by the director of IWAI Guwahati, who was the engineer in charge, by communications dated 1/12/2011 and 17/6/2013 are certifications given by the engineer in charge that the delay had occasioned due to reasons beyond the control of the contractor, that is the petition. And as such, the imposition of the liquidated damage on the basis of clause 14 is liable to be interfered with. On the other hand, Mr. S. Dr., the learned senior counsel, has submitted that the engineer in charge acts on behalf of the authority. And as such, he does not have any independent supervening power to give any certification or recommendation and certification without taking the approval of the competent authority. He therefore submits that a perusal of the communications dated 1/12/2011 and 17/6/2013 therefore stipulates, would clearly show that the engineer in charge had not certified and had only recommended further to that. The learned senior counsel for the respondent further to that, the learned counsel for the respondent submitted that a perusal of clause 14 would also show that for the purpose of invoking the force majeure clause, there's a requirement on the part of the contractor to notify within 15 days of the alleged beginning and ending thereof, giving full particulars and satisfactory evidence in support of such cause. He submits that this certification, this recommendation has been made pursuant to the completion of the contract. And as such, the exception for not invoking the liquidated damages as stipulated in clause 14 shall not apply. Isn't it? This court, after hearing the learned counsel, from the above submissions made by the learned counsels for the parties, and from a perusal of the pleadings available, pleadings and documents available, it transpires that the dispute involved herein not only touches on the interpretation of clause 14 of the standard conditions of the contract, but would also require various documents to be taken note of as to whether the exception whether the force majeure clause could have been invoked pursuant after the completion of the contract, or there are documents to the effect that during the period of the contract, steps were being taken by the contractor, that is the petitioner, for the purpose of invoking this force majeure clause. Next. Now coming to the arbitration clause, that is clause 21.1. It would show that all these questions, disputes or differences in respect of which a decision has not been final and conclusive arising between the contractor and the authority in relation to or in connection with the contract has to be referred to arbitration. This court cannot also be unmindful of Section 5 of the Arbitration and Conciliation Act 1996, which stipulates, where is that Arbitration and Conciliation Act? Which stipulates that all matters governed by Part 1, in respect of all matters governed by Part 1, no judicial authority shall intervene except where so provided in the said part. Full stop. Taking into account that the issue involved, the disputes involved herein pertains to interpretation of clause 14 of the standard conditions of the contract,
Special conditions.
special conditions of the contract, as well as because the interpretation of clause 14 on that, as well as to whether which touches on as to whether a certification, whether a recommendation so made by the engineer in charge after completion of the contract can be construed to be a certification in terms with clause 14 of the special conditions of the contract. And also taking into account that various disputed questions of facts, various factual determination has to be made. It is the opinion of this court that the interest of justice would be met if the parties are referred to arbitration by this court. Rather than adjudicating the dispute before this court. Referred to arbitration under Section 8 of the Arbitration and Conciliation Act 1996. At this stage, this court further finds it relevant to refer to a judgment of the Supreme Court in the case of Praveen Enterprise, State of Goa versus Praveen Enterprise, reported in 2012, 12 SCC 581. And more particularly, paragraph number 13, which connotes what does the reference to arbitration mean. The said paragraph is reproduced here in under. Taking into account the above judgment, this court therefore refers the parties herein to arbitration and leaving the parties to take recourse to their remedies by way of arbitration. It is further made clear that pursuant that the petitioner, the parties before this court may either agree upon an arbitrator and refer their disputes to him, oblique her, or failing agreement would be at liberty to take recourse to the provisions of the Arbitration and Conciliation Act. With the above, the instant petition stands disposed. Mr. Counsel, 2021, I would have dismissed.
Sorry.
Coming.
So that is our case, Lord. Now, second query before you, as your lordship inquired that, yes, all right, you have said so, but when you have filed an application, whether you have taken any leave from the court or not. That is the second question that has come from your lordship. So, my lord, I have perused this material on record, then it appears that yes, both the parties were hard and the court was of the view that yes, it should be hard. So obviously this leave was granted. This is my contention and nothing else. And so far marriage
No,
is concerned that we
if
should not accept.
No, Mr. Dasgupta, if 36.3 and 36.4 has not been complied with, the award may be bad. That's another aspect of the matter. The award, the legality and validity of the award may be bad. But the reason by which the labor court have set aside the order saying that he had only issued the notice for filing written statement and did not say thereafter what will happen in that notice, and as such he has given, that's not proper.
No, Lord, initially, my lord, the labor code was under an impression that the management is being represented by a lawyer. Because of the fact that the affidavit which was sworn by the management witness was identified by the lawyer. And he was under an impression that this management is being represented by their lawyer. And so that is that.
But you should have put an objection then and there.
The filing of objection does not arise at all because the order in this regard was already been passed that the proceeding will proceed, the proceeding ex parte.
So you can very well go and ask for vacating of the ex parte. You knew then what was the next date fixed for. Kindly see the order of 29/9/2008, page 39.
Page 39.
I copy that page 43, your lord.
Page 39. It's wrong. The typing is wrong.
Typing is wrong.
Are you saying that the typing is wrong?
No, I'm not saying that for the written is in
Ah.
39.
You filed the written statement on 29/9/2008.
So far, page 39 is still something else is in my 37. Page 37, 39.
See the order of 29/9/2008.
Record put up, management side, file WS with a copy of the workman. The workman is absent. Pick such and such by the workman.
So that is it. Then the next date, management side is absent without steps.
Notice to the workman.
Thereafter, the management
Sent
side is
through
absent.
post. Notice to the workman sent through post.
So
returned
at
with
that point
remark.
of time, at that point of time also, how can you say about the workman appearing through, whether he will appear through this lawyer or not? How will you come to know about all these things?
Both sides of the record put up to me on the getting officer is not on the screen. Record put up. Mine. Return the word 21/10/2000. Notice to the workman sent through post. Returned workman returned with remark that the name person was not found in a such as that was not reissue notice.
Then thereafter, the management has been absent all along. Then how did you know that the management is workman is represented by a workman?
The
by a
management
lawyer?
side is absent without state. So far my application is concerned. No. So far my application is concerned, I know that he is represented by a lawyer.
How did you know? Because you were never represented thereafter.
I can gather information from somewhere else.
See the order sheet. The workman did not appear till then. You filed your written statement first. The workman did not appear then. Thereafter, the workman appeared at a later stage on 21 7/8/2008, 11/2008. You have been all along absent.
Yes, I am all along absent.
Then
but
where is
that
the
does not
question?
mean that
How can you take
No,
the plea?
I am all along absent, but that does not mean that I can know the proceedings of the court.
How did you know? Show me that you knew it and you did not participate it. You must have stated somewhere.
In my application.
For that you challenge the award, that is another aspect of the matter, nothing to do with all these things. We set aside this. Uh, The instant writ petition has been filed by the petitioner challenging the order dated 28/3/2011 passed in Miss Case number 1/2010 arising out of reference case number 12/08. The facts leading to the filing of the instant writ petition are that the government of Assam by government notification number G.L.R.46/08/30 dated 4th of July 2008 referred the dispute that had arisen between the management, between the respondent number 1 and the petitioner to the Learned Labour Court, Guwahati, Assam. On the basis of which a reference case being reference case number 12/2008 was registered and numbered. The terms of reference in terms as per the said government notification dated 4th of July 2008 were as under are reproduced here in under. Into page 46 of Pabo, okay, 1, 2, 3, Roman 1, 2, 3. Page 46. From the order sheet of reference case number 12/2008 enclosed as Annexure B and B1 to the repetition, it can be seen, it would be seen that on 12/9/2008, the respondent number 1 appeared before the Learned Labour Court, whereas the workman, the petitioner was absent. And the Learned Labour Court fixed 29/9/2008 for filing of written statement by both the parties. On 29/9/2008, the management side, the respondent number 1 filed their written statement with a copy to the workman. The workman was absent on that date, and as such, the Learned Labour Court fixed 20/10/2008 for filing of written statement by the workman. On 2010-2008, the management side remained, the respondent number 1 remained absent without steps. The Learned Labour Court, taking into account that the service upon the workman, that is the petitioner, was not duly effected, directed reissuance of notice to the workman through process server and fixed 7/11/2008 for return of notice. On 7/11/2008, the workman appeared and filed a petition number 409/08, praying for adjournment to file written statement. However, the respondent number 1, that is the management, did not appear. On 21/11/2008, the workman, that is the petitioner, filed his written statement along with some documents. The management, however, remained absent. The management / the respondent number 1 remained absent. It further reveals from the entire order sheet which was produced by the learned counsel appearing on behalf of the petitioner. It further appears from the certified copy of the order sheet. Where is that? We have not produced the entire one.
No, this was only given to us. This is the entire thing.
It further appears from the certified copy of the order sheet of reference case number 12/2008 enclosed as Annexure B1. That the respondent number 1 chose not to appear in the said proceedings. Whereas, repeat. The Learned Labour Code by an award dated by an ex parte award dated 30/7/2009. Decided the reference holding inter alia that the respondent number 1 was not justified in discharging the petitioner from service, and the petitioner was entitled to reinstatement with full back wages and other benefits entailing. It was further directed that the petitioner number 1 shall reinstate the petitioner. It was further directed that the respondent number 1 shall reinstate the petitioner immediately and clear the back wages within 3 months. The said ex parte award was notified by the Government of Assam Labour and Employment Department by the notification dated 6/11/2009. subsequent thereto, by another communication dated 30/12/2009, the Assistant Labour Commissioner Ulubari, Guwahati, have forwarded the award in reference case number 12/2008 to the respondent number 1 as well as the petitioner. It reveals further from the record, more particularly Annexure 5, that a miscase was filed, a miscellaneous application was filed for vacating the ex parte award dated 30/7/2009 by the respondent number 1. It is interesting to note that the said application was filed by the respondent number 1 through an advocate. From a perusal of the said application, which was registered and numbered as miscase number 1/2010, the grounds so taken is that the petitioner, that the respondent number 1 did not take any leave of the court, as well as the consent of the petitioner, as required under the provisions of Section 36(4) of the Industrial Disputes Act 1947. And as such, there was no negligence or laches on their part in not appearing before the court, learned labor court, on the date fixed in the reference case. It was the specific stand of the respondent number 1 in the said application that they were under the impression that the said reference case would be heard after due compliance of the provisions of Section 36(4) of the Industrial Disputes Act 1947, and they would be intimated accordingly. To the said application, so filed, the petitioner filed objection stating inter alia that pursuant to the award being passed and notified, the learned labor court had become functius officio and could not have entertained such an application, cannot entertain such an application. It will further mention that in the Industrial Disputes Act 1947 or even under the Assam Industrial Dispute Rules 1958, there is no requirement of any intimation or notice to be given by the learned labor court to either of the parties after both parties in the dispute had appeared before it and filed their respective written statement. It may also be relevant herein to mention that an objection was raised on the question of delay in filing the application seeking vacation of the ex parte award. And for that purpose, evidence was also taken. Be that as it may, by the order dated 28/3/2011, the Learned Labour Court had set aside the ex parte award dated 30/7/2009 in reference case number 12/2008 and restored the reference case number 12/2008 to the file for contest. The Learned Labour Court had in the said order dated 28/3/2011 held that in the notice which was issued, it was stated that the parties were directed to, it was held that in the notice which was issued by the Learned Labour Court at the initiation of the reference case, the parties were asked to file their written statement along with the documents with a copy to the other side, with a further direction that the paper may be sent by post to reach the court at the headquarters at Guwahati on or before 26/8/2008. The Learned Labour Court further observed that in the said notice, nowhere it was stated that the parties were directed to contest the case by appearing in the court in all the dates, but only to send written statement along with the documents relied upon. In that backdrop, the Learned Labour Court held that the plea of the respondent number 1, that after filing of the written statements by them, the court will pass necessary order under section 36(4) of the Industrial Disputes Act and again called upon them to take steps in the case cannot be held to be an illegitimate belief. It is on the basis thereof the Learned Labour Court held that it amounted to a sufficient reason and ground for not taking steps in the reference case after filing of the written statement. The petitioner, being aggrieved, has therefore filed the instant petition challenging the order dated 28/3/2011 The instant writ petition was filed on 18th of May 2011 And this court, by an order dated 6/6/2011, issued notice and directed that until further orders, all further proceedings on reference case number 12/2008 pending before the Learned Labour Court Guwahati shall remain stayed. The state stay continues till date. The said interim order still continues to hold the field. Next. I've heard the learned counsels for the parties and have perused the materials on record. This court have also taken note of Promida Assam Industrial Rules. Taken note of the Industrial Disputes Act 1947, as well as the Assam Industrial Dispute Rules 1958. Section 11 of the Industrial Disputes Act 1947 stipulates that subject to any rules that may be made in the behalf, an arbitrator, a board, court, labor court, tribunal or national tribunal shall follow such procedure as the arbitrator or other authority consider may think fit. Rule 12 of the Assam Industrial Dispute Rules 1958 stipulates as to how the proceedings before the labor court oblique the tribunal are to be conducted. The said rule being relevant for the purpose of the instant dispute is reproduced herein under. Give me a photocopy. Agreed. From a perusal of the said rule, it transpires that the learned labor court within 2 weeks of the receipt of the statement referred to in sub-rule 1 perusal of the said rule appears, transpires that when the state government refers any case for adjudication to the labor court oblique the tribunal, it shall send to the labor court oblique tribunal concerned and to the opposite party concerned in the industrial dispute a copy of each such order of reference together with a copy of the statement received by that government under sub-rule 4 of Rule 11. Sub-rule 2 of Rule 12 stipulates that within 2 weeks of the receipt of the statement referred to in sub-rule 1, the opposite party shall file its rejoinder with the labor court or the tribunal as the case may be, and simultaneously forward a copy thereof to the other party. It has been further mentioned that the labor court or the tribunal, as the case may be, consider it necessary may extend the time limit for filing the rejoinder by any party. In terms with sub-rule 3 of Rule 12, the labor court or the tribunal, as the case may be, shall ordinarily fix the date for first hearing of the dispute within 6 weeks of the date on which it was referred for adjudication. However, a discretion has been given to the labor court or the tribunal, as the case may be, for the reasons to be recorded in writing to fix a later date for the first hearing of the dispute. As per sub-rule 4 of Rule 12, the hearing shall ordinarily be continued from day to day and the argument shall following immediately after closing of the evidence. Sub-rule 5 stipulates as to under what circumstances and for what period adjournments can be granted. Therefore, a reading of Section 11, a conjoined reading of Section 11 of the Industrial Disputes Act 1947, as well as Rule 12 of the Assam Industrial Disputes Rules 1958, would show that save and accept what has been provided in Rule 12. The Learned Labor Court oblique the tribunal shall follow such procedure as may think fit. Now, coming to the facts involved in the instant case, it will be seen from a perusal of the order sheet of reference case number 12/2008 that pursuant to the notice received by the respondent number 1, that is the management, they appeared before the Learned Labor Court and sought for an adjournment for filing of the written statement. Thereupon, the respondent number 1, that is the management, appeared on 12/9/2008 and sought for an adjournment for filing the written statement. Thereupon, on 29/9/2008, the management, that is the respondent number 1, filed their written statement with a copy to the workman. However, thereafter, the management oblique the respondent number 1 did not care to appear before the Learned Labor Court. Now let this court test. Did not care to appear before the Learned Labor Court. Although the Learned Labor Court had passed specific orders, did not pass any order exempting the management oblique the respondent number 1 not to appear before the Learned Labor Court till the appearance of the workman. It is further seen that that the workman appeared on 7/11/2008 upon receipt of the notice and thereupon filed his written statement on 21/11/2008. A further perusal of the order sheet does not show that the Learned Labor Court at any point of time thereafter also had exempted the management not to appear. Now, in the backdrop of the above, let this court therefore test the reasons assigned for non-appearance before the Learned Labor Court by filing the application for vacating the ex parte award dated 30/7/2009, isn't it? The reason so assigned is that the management, that is the respondent number 1, was under a bona fide belief that
There are 6 of the.
that after filing of the written statement by them, the court will pass necessary order under section 36(4) of the Industrial Disputes Act and again call upon them to take steps in the case. Let this court therefore take note of what is section 36(3) and 36(4). In terms with section 36(3). No. Let this court
No.
take note of
Sorry,
what
look.
is.
So I have not referred one judgment. But you are now, I also make only consider because deliberately I have not referred it. Till then, you are also dealing.
What is this?
Because you are also dealing with this
Project
aspect.
trust, Your Lordship.
Eh?
These two judgments which has been now referred to the larger.
Yeah, otherwise I would not have referred this thing. Otherwise also- Because
Refer for what?
this-
Because of in Pradeep Trust, the Advocate Act, they said that
No,
there
just-
was a
let it-
in the last.
Dawa-
paragraph,
Dawa-
it's been-
Dawa- Dawa-
Yes,
Dawa-
tell me.
It was
You also
held-
can go through the judgment as well that day. Deliberately I have not referred it.
Advocates Act was held to be a general act. The Industrial Dispute Act was held to be a special act in Pradeep Court. And the court said that this thing is not altered riders and the advocate cannot, as a matter of right, have a say before the better. However, recent judgment has said that Advocates Act is also a special act. Because it cannot be said to be a general act because the observation of Pradeep Trust. Port trust cannot be held to be a correct viewpoint and so the matter.
No. Why should I go into all these
So
things?
that is not the requirement.
No, Mr.
At the judgment,
Datta, I would not go into all these things. These are not necessary. You hear my judgment.
Yeah, that will be better.
Not necessary. I'm not going into that intricacies
If you are
as
not-
to whether an
go-
advocate can appear or not.
Hmm.
Whether an advocate without leave can appear or not is a question which may render the award illegal. But that can be not be a subject matter of setting aside that you have to give another notice. I'm not on that. I'm not on whether the advocate can appear without or not. It may be illegal. The award may be illegal, but why should this court not interfere on the basis of this? You may challenge the award later on. That is your lookout.
What the judgment is concerned is straight that the advocate can appear after having the leave of the court.
Understood?
So that is
No,
the problem.
No,
Because
no.
now we don't take leave from the court.
That is why I kindly hear to my judgment and then you say, yes, now kili. What is section 36 of the Industrial Disputes Act 1947? Section 36(1) stipulates that a workman who is a party to the dispute shall be entitled to be represented in any proceedings under the said act of, under the Industrial Disputes Act of 1947 by any member of the executive or other office bearer of a registered trade union of which he is a member. Or by any member of the executive or other office bearer of a federation of trade unions to which the trade union referred to in clause A of section 36(1) is affiliated. Or where the worker is not a member of any trade union by any member of the executive or other office bearer of any trade union connected with or by any other workman employed in the industry in which the worker is employed and authorized in any such manner as may be prescribed. In the similar vein, section 36(2) stipulates that an employer who is a party to a dispute shall be entitled to be represented in any proceedings under the Act, Industrial Disputes Act 1947 by an officer of an association of the employers of which he is a member, or by an officer of a federation of association of employees to which the association referred to in clause A is affiliated, or where the employer is not a member of any association of employers, comma, by an officer of any association of the employers connected with or by any other employer engaged in, comma, the industry in which the employer is engaged and authorized in such manner as may be prescribed. Therefore, a perusal of section 36(1) and section 36(2) of the Industrial Disputes Act stipulates who can appear on behalf of the workman and the employer, respectively. Section 36(3) stipulates that no party to a dispute shall be entitled to be represented by a legal practitioner in any conciliation proceedings under the Act, under the Industrial Disputes Act 1947, or in any proceedings before a court. At this stage, it may be relevant to take note of the word court had been defined in section 2F to mean a court of inquiry constituted under the Industrial Disputes Act 1947. Now coming to section 36(4) of the Act of the Industrial Disputes Act 1947. It is mentioned that in any proceedings before a labor court, tribunal or national tribunal, a party to a dispute may be represented by a legal practitioner with the consent of the other parties to the proceedings and with the leave of the labor court, tribunal or national tribunal as the case may be. Now, coming back to the facts involved herein, it will be seen that the respondent number once, that is the management, stopped appearing in before the learned labor court in reference case number 12/2008 after filing of the written statement, even before the appearance of the workman. This court have also perused the Industrial Disputes Act 1947 as well as the Assam Industrial Disputes Act, Dispute Rules 1958. And there is no provision which stipulates for issuance of notice after filing of the written statement, this court is further of the opinion. No, this court further. Upon a perusal of section 36(4) of the Industrial Disputes Act 1947, also do not find that a notice is to be issued for obtaining consent from the other party if the other party is not appearing before the court. For being represented by a legal practitioner. Under such circumstances, this court is therefore of the opinion that the findings arrived at by the learned labor court to the effect that after filing of the written statement, the court would pass necessary order under section 36(4) of the Industrial Disputes Act and again call upon them to take steps in the case. Is completely contrary to the scheme of the Industrial Disputes Act 1947, as well as the Assam Industrial Disputes Rules 1958, and more particularly, and also section 36(4) of the Act of Industrial Disputes Act 1947. Consequently, this court, therefore, is of the opinion that the order dated 28/3/2011, so passed by this court, is erroneous and contrary to the provisions of law for which the said order dated 28/3/2011 passed by the Learned Labor Court Guwahati in Miss Case number 1/2010 arising out of reference case number 12/2008 stands set aside and quashed. Full stop. The award dated 37/2009 in reference case number 12/2008 is restored. The respondent number 1 shall take appropriate steps for compliance with the terms of the award in terms with the Industrial Disputes Act 1947, and failure to do so shall entail the consequences as provided therein.
Item number 13, part heard.
Obliged.
Yes, madam, did you get anything?
My lordship, I have received the original record from my lordship perusal. Under what circumstances the government has passed the order? Lordship may
No,
kindly
no,
have
no,
a
no,
look.
no, no. Oh, what government has passed is okay, but does the government have the power?
Yes, Lordship, before that,
Lordship, before my learned bench start, Lordship, today on morning I have received the telephonic instruction from the MD ASTC, Lordship. They will reconsider the matter of the petitioner, Lordship, in the next board meeting, which will be held within 15 days. Lordship.
First is their case. We set aside, then you reconsider. First tell me whether you have the power.
Lordship may kindly have a look. The Road Transport Corporation Act 1950 for a moment, my lord.
Where is it?
Lordship, that
But
copy.
দিছিলে এখন
lordship have
কিতাপ
the
হতে
lordship
রঙা
file.
নীলা কিতাপ এখন আছে এই সুপার ইতি সুপার করি করি
So before it, my lord, may kindly have a look the original record for a moment.
Right?
Lordship,
I'm not going to look into. First you have the power. You show
Right.
me the power, I'll look everything.
my lord,
You will show me the power.
Lordship. Lordship, got the copy, my lord?
All matters so much of litigation.
Segment for the- And I have received another instruction from the AMD ACC also, that
Because madam,
my lord,
if there is any illegality, you take it.
my lord,
Let these people take,
my lord.
but not you.
My
Yes,
lord,
tell
is
me.
absolutely correct, my lord. But before that, lordship may kindly have a look, section 44 for a moment, my lord.
Hmm.
44, power to make rules, my lord.
Yeah.
Lordship got it, my
44,
lord.
yeah.
44. The state government may, by notification in the official gazette, make rules as given effect to the provision of this act, my lord. Number 2, in particular, lordship, my copy is not legible. Lordship, copy is legible, my lord.
এই নে এখন দেখা পাইছো না এখনই নেকি লৈ গ'ল নেকি? Yes, we are referring to
44, my lord.
44, which
44.
clause?
44, lordship, I just read clause 1, my lord. The state government may, by
That is okay. Then
lordship, 45, power to make regulation.
yes, then
Here is also a corporation may, with the previous sanction of the state government, make regulation in not inconsistent with the act and the rules made thereunder for the administration of the affair of the corporation, my lord.
Hmm.
This is the power of the state government. They have to take approval from the government before make any decision, my lord. Then lordship may kindly have a look for a moment. The Road Transport Corporation Amendment Act 1982, my lord. How the Board of Director consisted, my lord.
where is it? Yes,
Yeah, lordship, amendment, yes, lordship, from
1970 rule.
1982, Amendment Act 1982. Road Transport Corporation Amendment Act 1982.
Road Transport Corporation Amendment. Yes, then
Then clause 5(1), my lord. The general superintendent's direction and management of the affair and business of the corporation shall vest in the board of the directors, which with the assistance of the committee and managing director may exercise all such powers and do all such acts and things as may be exercised or done by the corporation. The board shall consist of a chairman and such other directors, being not less than 5 and not more than 17, as the state government may think fit to appoint.
Hmm.
The directors has been appointed by the government, my lord.
Hmm.
Then the state government may, if it is so thinks fit, appoint one of the other directors as the vice chairman of the board, my lord. These are the powers vested by this act to the government, my lord.
now
The
tell me, I have been appointed by the president. Can this judgment be passed by the president? Then I have to pass.
My
then how
lord is
does it
absolutely
happen?
correct, my lord.
Then
I have
show me the
nothing to
power. Then
Lordship. I am assisting my lord, but lordship may kindly have a look the original record for a moment, my lord. Lordship,
understood.
my
But the
lord.
thing is, where is the power?
It was not defined anywhere, my lord. My lord is absolutely correct, but only
Because you
44
see,
and
I have
45,
passed one judgment that is also one case pertaining to Nagaland.
my lord.
There, what happened as regards some retirement or something.
My lord.
there was the power to make regulation which is here
Lord,
is given to the board.
Lord.
But the state government has the power to set aside the entire regulation, override that. But the
Right.
question arose as to whether the state government could amend. You see, the state government has the power to say that we are not going to go by this.
Lord,
The state government, if you see section 38 or 39 out here,
my lord,
has the power to remove the entire board,
my
to
lord,
take over the management. Even say that this ASTC corporation, we are making it defunct, so everything will now belong to the state.
Yeah.
All this power is there.
my lord.
But does the state government have the power to,
Set aside the board of directors
Ah.
decision, my lord.
no,
My lord is absolutely correct. But my lord, Lordship may kindly have a look 179 board of directors meeting for a moment, my lord.
Hmm.
The clause 6,
Six.
my lord, the miscellaneous agenda. Oh, it is the review meeting, my lord.
Hmm.
This was the 170th decision which were cancelled. It was reviewed in this board of directors meeting. It was on 179 board of director meeting held on 21/5/2021. Then 6/1, my lord.
179 is on 510.
My lord, and it was cancelled on in the month of June, I think.
No. You see, kindly see
My lord,
number 6A,
my lord, yes, my lord,
miscellaneous agenda.
my lord. The view,
Thoroughfare to Kalimandi on ASTC Road at Rupnagar campus.
Lord,
POD deliberated upon the issue on the proposal for allotment of land for giving access to any person, organization or leasing out to done with due procedure.
my lord,
Hence, the BOD disapproved the MOM on minus of the meeting on this matter of the earlier and in principle approves the decision of the government of India. However, as the matter is subject, the final decision may be taken after the disposal of the honorable court.
yes,
That means no decision has been taken.
my lord,
You have taken this,
Hello.
this is not, but we are not taking any decision as the matter is pending.
before the
So,
honorable court,
as of now,
my lord,
the cancellation has only happened on the basis of the minister, the secretary,
secretary's order, my lord,
who has no authority. So we set aside, you do whatever you feel like.
my lord. Lordship may directed the board of director to take a call, my lord.
Lordship, if the 178 board meeting has been set aside by your lordship means.
Yeah.
If your lordship set aside the secretary's order, lordship, then many of the decisions which were already been reviewed in 179 board meeting. Means the board meeting, 178 board meeting which were
No,
already been
no,
placed,
Mr. Das.
lordship.
You see, in the 179 meeting, you have taken many other decisions.
Lordship.
But the decision as regards this land, you have not taken in view of the pendants.
My lord,
Lordship,
my
lordship.
So
Lord.
as regards those meetings which you have done under 179, that will hold the field. But as regards at 6A, you have to take a call now in view of my decision. I'll set aside this secretary's order, take a call,
In regards to this matter only, my lord.
because that you have not taken
My
a
lord.
decision.
Only in regards to this
This
matter only.
matter.
lordship.
Only 6A, because
Lord,
others
Lord,
we have
Lord.
already done, the discuss
My
and so and decided the committee may be formed to verify the COVID expenses and so and so.
Yes, yes,
That's
yes,
why- That you have done.
yes, yes.
That is not made subject to. But here you, this regularization of the post, just for example, number K, the matter is under inquiry of so and hence the bishop should drop the matter for the agenda list for the further decision. Now, this has already happened.
Ma'am.
I'm not saying anything on this. Now, kindly see appraisal of uses of vehicles for vigilance, inspection and further so and directly under the supervision. Matter is duly approved by the BOD, ASTC as for the endorsement in the minutes final for the meeting of the earlier BOD. Now, this has, you have already done.
Done.
This I'm not. But here if you see 6,
Yeah.
6A, my
you
lord.
have not taken a decision in view of the
My lord.
pendant. So what we do is set aside this to the secretary, you take a call, but secretary has no business of it.
Lordship. In
Lordship may set aside only in
this matter.
this
only.
matter.
Only second,
My
Yeah,
lordship,
only-
lordship,
only that this
Yeah.
is only
My
limited to
Lordship,
this.
lordship.
lordship may pass.
And
appropriate
in
order.
fact, what has happened? The secretary has no business. The entire secretary thing has to go. However, your 179 board meeting will be there.
Lordship.
If you have taken any decision in respect of anybody,
Lordship.
that will be good.
Lordship.
That will be good for them. Only, but for him, you have not taken any decision.
Lordship.
So we'll pass the order.
My lord.
Lordship.
So Lordship, this
Mr. Ali, Mr. Ali, your only thing is these two orders, secretary.
Towards one is 16.6.
Whatever may be,
The
you
other
want
one-
this to be set aside.
That was followed in 29/6/2021. That is so your lordship. Is affected. the
In
fundamental
fact, my lord, the petitioner has
So-
no locus to challenge the secretary's order. Lordship is going to pass an appropriate order.
No, I'll pass the order. At two.
So the follow-up action, your lordship, it is 29/6/2000.
Where?
That is annexure 12, your lordship. By
Then
annexure
MD
12
has
of
issued his
92.
cancellation order that lordship.
92. Page 92, your lordship. On the basis of that, the my.
No, this I will, yeah, because here the board of directors have
Yes.
not. The managing director
My lord, my
wouldn't
lord,
have done.
my
So
lord,
we
my
set aside this.
Both-
You wait,
both-
Mr. Ali, don't go to civil court so soon.
No,
We'll take up the matter at two. I'll dictate in your presence. Anything you want to say, you can.
Their lordship, so that their lordship, so that there are number of things on the Supreme Court, the most important is your lordship. That is the petition 2004 3 553,
For what?
that is that when if there is disputed question, there is no disputed question, they have not disputed the agenda. Only thing your lordship, they have without any cause or being shown any reason, your lordship, they have communicated. But even if there is cause or shown causes also, your lordship, in that case also, your lordship, is under Article 26, the honorable court has immense power, your lordship. If the order passed is unreasonable, unjustified, and
Mr. Ali, I will pass the order in your presence. You want to add something, I will hear to them. Yes.
no, your lordship, both this notice maybe your.
I will
lordship-
pass the order at two in your presence. Which one? Petitioner died. What is the matter about?
Lordship, petitioner was an employee of the Assam Agriculture Marketing Board. He was suspended in the year 2007. After inquiry, his two income has been dropped. And he retired in the year 2009. All the retirement has been released. Lordship. And
So
he
nothing
also-
remains.
Nothing remains. Lordship.
Item number 4, na?
Whole lordship.
You have dropped the disciplinary the penalty. What have you done?
It was not the lordship. Not the lordship. Who increment has been withheld. Lordship. In the page 23, lordship. Page 23, the increment order. Lordship.
No. No, if you have imposed. Where is the penalty?
Penalty lordship in the page 23 of the writ petition.
Page
23. Pension order is page 12, Lordship. And allegation of charges is page 14.
Why did you initiate disciplinary proceedings against him?
Lordship,
Did not
Actually-
handing over the charge.
his charges is Lordship at page 14, Lordship. Allegation of charges. Dated 01/11/2007. He has not hand over the charge to the other income tax.
No, are you not imposing two penalties upon him? The first is for two increments. That is okay. I won't touch it. But what about the only paying him only subsistence allowance of 50% and not the remaining?
That is not with me. We have also not earlier accident has not file, returned the file of it. I only record from the file of it, both file.
But then
But,
would he not be entitled to the remaining? Wouldn't it be double penalty imposed upon him?
50% is entitled.
Is he entitled to the remaining 50%? Because I would have understood if it is a case of, because here you are reducing the amount he's otherwise entitled to.
In between he expired, it expired in instruction.
You say that the petitioner had expired. When?
In 13.
Hmm?
Lordship, in the year 2013,
He expired. Then
that's not a bad.
how do you know that the petitioner expired in 2013?
Sir told me.
You told me.
I talked with the authority, like, they informed that he expired also. Also, then today,
When?
according to telephone instruction, in 2013.
When?
Date is not with me, Lordship. So, Lordship, can we fix another date?
You have no contact.
He also no contact.
No, Lordship.
He retired on Lordship 13/9/2009.
Okay. It has been brought to the attention of this court that the petitioner had expired in the year 2013. No steps, however, has been taken by the legal representatives of the petitioner for the purpose of continuing the instant proceedings by filing appropriate application for substitution. Taking into account that the petitioner had already expired, this court is not in a position to proceed with the matter at the behest of a dead person. Consequently, the instant petition stands closed as a wait.
Much obliged.
Mr. Sheikh, that matter, we'll have it on some other day, as Mr. Borpuzari is not there.
No,
When do you want it?
Monday, my lord. Because, my lord, it is of 2016 matter, it's simple point involved. It will take, from my side, my lord, it is about 15 minutes.
And when
Because
I
the
am,
only thing is this.
I tend to
Only
pass
thing
an
is
order against you, it will go to a half an hour.
My lord, what happened, my lord? Actually, some order has been passed in our favor in 2009. Subsequently, my lord, Supreme Court decided a law that the land which is reserved for a particular purpose, that should be used for that purpose. So my point before your lordship is this, whether that judgment will affect the 2009 order passed by your lordship. Only whether that judgment of the Honorable Supreme Court will be given retrospective effect or it will be prospective. This point is to be decided. The other thing is all right. Land was allotted in our favor. Everything
Allotment
is
process is
done.
going on, not allotted, logic. Allotment process is going on. In the meantime, Supreme Court judgment kept.
Allotment has not been made.
Not made.
So if the allotment, this is pertaining to the village grazing ground or
This-
community land,
Yeah,
Yes, increasing land.
the
Yes.
community land.
coming.
My lord, actually, what happened, that proceeding is going on. That is not the thing, because the government in affidavit said for 73 persons, landed person, 1 bigha of land is allotted. And in the meantime, my lord, after about recently, my lord, after about a long time, my lord. they
Now, is
funded
there
new
any
petition.
order passed by this court
Yes,
to
ma'am.
give you allotment?
Yes, ma'am.
No consideration.
Yes,
No,
ma'am.
consideration is not there.
Not there.
Giving allotment.
No, not there.
Allotment is there, my lord. Your lordship will see the judgment passed by your lord.
No, wait. I am in the midst of,
That's-
let
yes,
me
yes.
dictate
Hello.
this order, then
Yes,
we'll look
It
into.
is simple point, my lord. I'm.
Simple
running-
point, we will deal with in a simple way. Let me
My lord.
first complete with Mr. Ali's
My
matter.
lord, my lord.
He has to go rush to the
My lord.
civil court for moving
My lord, I
injunction
was in the
matters.
hope that I am in the past, so my case will be taken by your lord.
But your matter is not parted.
No, not part heard, my
So
lord.
let me complete the parted.
My lord. Oblige.
The petitioners, who are 3 in number, the 3 petitioners before this court have jointly assailed the order dated 16/6/2021 issued by the respondent number 5, semicolon. The order dated 17/6/2021 issued by the respondent number 2, and the letter dated 29/6/2021 issued by the respondent number 2. The facts, as could be discerned from the pleadings, is that are there that the petitioner purchased a plot of land measuring the petitioner jointly purchased a plot of land measuring 8.02 R that is land measuring 4.01 R covered by DAG number 1120 of KP Patta number 110 and land measuring 4.101 R covered by DAG number 1119 of KP Patta number 417 of Revenue Village Ulubari under Moja Ulubari in the district of Kamrup Metro, Assam. By the registered deed of sale bearing deed number by the registered deed of sale dated 21/9/2018. The said land belonging to the petitioner have been specifically described in Schedule Roman 1 of the writ petition. It is the case of the petitioner that in order to egress and ingress to the Schedule 1 land from the main road, that is Rupnagar main road, there were two paths which were specifically described in Schedule Roman 2 and Roman 3. To the writ petition. Next. It is the further case of the petitioner that the state of Assam had allotted a plot of land measuring about 91 bighas to the respondent number 1 corporation covered by DAG numbers 278, 279 and 280. The said aspect of the matter can be seen from the application filed by on the said land. The respondent number 1 corporation had constructed staff quarters and have left almost 60% vacant land on the southern side since last more than 30 years. This vacant area have been used by third parties on 22/12/2018 at around 8:30 a.m. A representative of the respondent number 1 came along with workers for construction of a gate at the entrance point of the Schedule 2 pot. The petitioners, along with other people in the locality, requested the concerned contractor not to do so. It has been alleged that there has been certain altercations between the petitioner and the employees of the respondent number 1, which resulted in initiation of a proceedings under section 147 of the Code of Criminal Procedure 1973 before the learned additional district magistrate Kamrup Metro Guwahati, which was registered and numbered as 26 M2 Porot oblique 2019. A police report was called by the additional district magistrate Kamrup Metro as regards the incident, and on 30/9/2019 the police officials submitted the report. Thereupon notice was issued to the respondent number 1. It is a further case of the petitioner that the Schedule 2 pot thereafter continued to remain blocked from 22/12/2018, and there was no effective order passed in case number 26 M/2019. Under such circumstances, the petitioners proposed an amicable settlement of the entire dispute. Before the learned additional district magistrate, Kamrup Metro. The learned additional district magistrate thereupon informed the petitioner that if they wanted any amicable settlement of the dispute, the petitioner may approach the respondent number 2 directly. Accordingly, the petitioner number 1 approached the respondent number 2. Who in turn informed the petitioner number 1 that the decision can only be taken by the respondent number 1. And such decision has to be have the approval of the board of directors of the respondent number 1. Accordingly, the proposal of the petitioner was placed in the 178th meeting of the board of directors of the respondent number 1 held on 21/5/2021, along with various other items. On 21/5/2021, in the 178th meeting of the board of directors, various items in the agenda were discussed. The item pertaining to the petitioner's request proposal was taken as a miscellaneous item. In the same meeting, the board of directors, upon discussion, decided and given approval to utilize existing approach road of Kalimundi for his landlocked plot of land, with the condition that he cannot claim ownership at any stage at present or in future for the said route. Had given approval. Huh? Taking into account its importance for the purpose of deciding the instant dispute, the same is quoted here in reproduced here in under. It will say page 73 to say utters of board has approved the utilization. Page 74 demand pin like it. From the above quoted resolution, it would be seen that the petitioner was only allowed to utilize the existing road. Petitioner were allowed to only allowed to utilize the existing approach road at the Kalimundi from their landlocked plot of land, with the condition that the petitioners cannot claim ownership at any stage at present or in future for the said route. Another condition so imposed was that the petitioners that there shall be no development of the construction activities on the pathway by the petitioner further to that, the respondent number 1 may charge one-time applicable fees for use of the said land as route. And a committee was to be formed constituting of the chief engineer (civil), advisor technical to MD and DS Rupnagar to determine the one-time fees to be collected. It is the further case of the petitioner that it is further seen from the records that on 7th of June 2021, the managing director of the respondent number 1 informed the petitioner number 1 that the committee had fixed rupees 18 lakhs as the applicable fee for use of the approach road. And further stipulating the conditions which have been mentioned in the resolution as quoted here in above. It is further seen that an deed of agreement was entered into by and between the managing director of the by and between the respondent number 1 through the managing director with the petitioner number 1. Wherein various conditions were mentioned. Date to column 9. Deed of agreement dated 9/6/2020. It is the case of the petitioner that the petitioner had duly paid the amount of rupees 18 lakhs to the respondent number 1 pursuant to the said agreement. Thereupon, was Mr. Ali, how did you come to know about 16 June and 17 June letters?
Letter it is reflected from the communication
Hmm?
asked your lot. It is from 29/6, 29.
From 29/6, you know. Okay. Thereupon, all of a sudden, on 29/6/2021, thereupon, all of a sudden, the petitioner received a communication issued by the managing director of the respondent number 1, dated 29/6/2021, wherein it was mentioned that in pursuance to the order and direction of the government of Assam by order number TMV.370/2015/PT.261 dated 16/6/2021, and in view of the office order number ASTC/BOD/2048/2021-22/1096 dated 17/6/2021, the right given to the petitioner for use of the pathway measuring 25 feet wide approach road in ASTC Rupnagar, Guwahati on payment of a one-time applicable fee was cancelled with immediate effect. It was further mentioned that the agreement executed between the petitioner number 1 and the ASTC was also cancelled. And the petitioner number 1 was requested to contact the appropriate authority of the ASTC for refund of the one-time applicable fee for use of the approach road within 7 days from the date of the receipt of the said letter. The petitioner thereupon could get hold of the orders dated 16/6/2021 issued by the Secretary to the Government of Assam Transport Department, whereby the said official cancelled the decisions taken in the 178th meeting of the Board of Directors held on 21/5/2021 with immediate effect, as the said resolution decisions so taken in the said meeting of the Board of Directors were inconsistent with the laid down procedures and rules. The petitioner could also get hold of the copy of the order issued by the managing director of the respondent corporation, wherein in pursuance to the order of the Secretary, Government of Assam Transport Department, dated 16/6/2021, all orders issued / actions initiated on the basis of the 178th meeting of the Board of Directors were cancelled with immediate effect. The petitioner being aggrieved by the order dated 16/6/2021 issued by the Secretary to the Government of Assam Transport Department, as well as the orders dated 17/6/2021 issued by the respondent number 2, that is the managing director of the respondent number 1 corporation, and the communication dated 29/6/2021. Issued to the petitioner number 1 by the managing director of the respondent number 1 corporation, have approached this court by filing the instant writ petition. It appears on the records that the respondent numbers 1, 2, and 3 had filed their affidavit in opposition on 3rd of March 2022. In the said affidavit in opposition, various statements have been made refuting the claim of the petitioner. But what is relevant to take note of is that the actions so taken by the respondent number 1 and 2 were based upon the order dated 16/6/2021 passed by the respondent number 5. It is very relevant to take note of that the respondent number 5 had also filed an affidavit in opposition through the Joint Secretary to the Government of Assam Transport Department, It is relevant to take note of from a perusal of the said affidavit in opposition so filed. That a secretary to the government of Assam Transport Department was present in the meeting as a member of the ASTC board. During the meeting, he objected to the agenda being taken. And further, on the ground that two vital members from the finance department and the public enterprise department were not present in the meeting. However, the said agenda, however, the board of directors passed the resolution on 21/5/2021 in its 178th meeting of the board of directors. Subsequent thereto, the Secretary Transport Department, who could not have his way in the meeting of the board of directors, have cancelled the entire proposal, have cancelled the entire meeting, the decisions taken in the meeting, by the impugned order dated 16/6/2021.
Record paragraph 5.
That's paragraph 5 and 6. I'm reading from
From
your affidavit, paragraph 6.
6 Lordship recorded 5 also may kindly record. The draft minutes was never vetted to the member present.
But all said and done, you could not have your way out there in the meeting. Now, after that coming out, you say that I'm cancelling it. How can you do that?
That is not the issue.
You want pictures? I can pass pictures against you.
Madam.
I think that is the best way. He couldn't have a say out there in the meeting. Nobody listened to him. And therefore, he comes out and says that the entire meeting is bad.
That apart, also affidavit has not been filed by him.
It's okay. Now, let us
however.
assume whatever may be. But whatever may be, this is what has happened.
Person was not present.
Anyway, the petitioner have also filed a reply affidavit to the affidavit in opposition filed by the respondent number 5. This court, upon hearing the learned counsels for the parties, this court have duly perused the pleadings and have heard the learned counsels for the parties. During the course of hearing, a specific question arose as to whether the Secretary Transport Department had any authority or jurisdiction to pass the order dated 16/6/2021. In as much as the land in question belongs to the respondent number 1, which is a corporation, which is a statutory, which is a corporation established on the basis of the Road Transport Corporation Act 1950. This court heard the matter. heard the matter at length on 1st of August 2023, on which day the learned counsel appearing on behalf of the Transport Department of the Government of Assam, on which date a specific query was raised to the learned counsel appearing on behalf of the Transport Department of the Government of Assam as to whether, in terms with the Road Transport Corporation Act 1950, including the amendments carried thereupon in respect to the said as amended up to date, as amended up to date, as well as the rules and the regulations so framed, whether there is a power of the Secretary of the Transport Department to override the resolutions so taken and adopted in the meeting of a board of directors of the respondent corporation, respondent number 1 corporation. During the course of the hearing, this court have also drawn the attention to the learned counsel appearing on behalf of the respondent number 5. Section 5 of the Road Transport Corporation Act 1950, as was amended by the Road Transport Corporation Amendment Act of 1982. Wherein the general superintendents from a direction and management of the affairs and business of the corporation have been vested upon the board of directors which, with the assistance of its committees and managing director, shall exercise such powers and do such acts and things as may be necessary by the corporation. Ms. M.D. Bora, the learned counsel appearing on behalf of the respondent number 5, with all fairness, submits that although the state of government has various powers, as could be seen from section 34, 38, 44 and 45. But the Road Transport Corporation Act 1950, as well as the rules and regulations framed therein under, do not empower the Secretary of the Transport Department of the Government of Assam to override the resolutions or decisions so adopted by the Board of Directors in its meeting. This court further finds it also relevant to take the submission of Mr. R. M. Das, the learned counsel appearing on behalf of the respondent number 1 and 2, 1, 2, and 3, who submits that pursuant to the decision so taken in the 178th meeting of the Board of Directors held on 21/5/2021, and further the orders which have been impugned in the instant proceeding, the Board of Directors of the respondent number 1 had in its meeting dated had in its 179 meeting held on 5/10/2021 had also nullified all the decisions so taken in the meeting held in the 178 meeting held on 21/5/2021, save and except the decision which is the subject matter of dispute in the instant proceedings, taking into account the that the said dispute is presently pending before this court. The learned Mr. Das further submits, while drawing to the attention of this court to the minutes of the meeting of the 179th meeting of the Board of Directors held on 5/10/2021, and more particularly to clause Roman 6 small a, wherein the Board of Directors have categorically stated that as the matter is sub judice, no final decision. The final decision would be only taken after the disposal by this court. Mr. S. Ali, the learned senior counsel, the learned counsel appearing on behalf of the petitioner, had submitted that the respondent number 1 corporation is a statutory body incorporated on the basis of the Road Transport Corporation Act 1950. Upon the land being allotted to the respondent number 1 corporation, the state government cannot have a say upon the said land. Referring to the judgment of the division bench of this court in the case of Bongaigaon Municipality versus Assam State Transport Corporation, reported in 2007 Ford GLR 616, the learned counsel submitted that this division bench of this court had also held on an earlier occasion that the state government is not entitled to intrude into the properties vested in the corporation at its will and pleasure. From the above contentions so raised by the respective counsels appearing on behalf of the parties, and there being no provision in the Road Transport Corporation Act 1950 which grants a supervening power upon the secretary of the transport department to override the decisions of the board of directors. This court is of the opinion that the orders dated 16/6/2021 passed by the respondent number 5 is on the face of it without jurisdiction and authority. And as such, the said order dated 16/6/2021 is set aside and quashed. Now coming to the orders dated 17/6/2021 and 29 and the letter dated 29/6/2021 issued by the respondent number 2. It transpires therefrom that the said order dated 17/6/2021 as well as the communication dated 29/6/2021 is based upon an order passed by the secretary, passed by the respondent number 5, which is non-est in law. Accordingly, the orders dated 17/6/2021 as well as the communication dated 29/6/2021 of the respondent number 2 is therefore interfered with and accordingly set aside and quashed. Mr. R.M. Das, the learned counsel. Before concluding, it is also relevant to take note of the submission of Mr. R.M. Das, the learned counsel, appearing on behalf of the respondent number 1, wherein he says that, wherein he submits that the decisions of that the quashing, the setting aside and quashing of the orders dated 16/6/2021, 17/6/2021, as well as the communication dated 29/6/2021 should not prejudice the respondent number 1 and its board of directors to take any decision as permissible under law. Taking into account that this court have only interfered with the order dated 16/6/2021 passed by the respondent number 5 on the ground that he has no authority or jurisdiction, and the other, and as well as the order dated 17/6/2021 and the communication dated 29/6/2021 on the ground that the said order and communication is based upon the order dated 16/6/2021. This court clarifies that the instant judgment shall not preclude or bar the respondent authorities to take such decision as permissible under law. It is, however, observed that the respondent number 1 corporation being a state within the meaning of Article 12 of the Constitution shall act fairly while taking such decision.
Deeply obliged, my lord.
Who passed the order?
My lord, this is Governor of Assam, my lord.
No, no,
On
who
the-
passed that order under Assam?
This is secretary to the government of Assam, sir.
Who passed that order? Which has been sealed?
Oh.
Under section 5.
My lord.
Now he filed.
Oh, this is MD, my lord, managing director.
MD won't do it. Who has passed the order? MD has not been made, na? A particular person. is
15,
doing
no,
it.
15.
The office has not been made. Is pleased to appoint Sri Rahul Chandra Das,
That.
ACS MD so and so, and Deputy Secretary for the Assam year to protect the assets of so and so. So he has been only appointed.
Yes.
Then who has passed this order?
Lordship say 101 eviction order is there.
Is this Rahul Chandra Das?
Yes.
Okay. Now tell me, did you issue the notice?
Yes, page 26.
Page
26.
20.
6.
Page 26 is a notice
Sure.
issued on 6th of August 2021.
Yes.
At that point of time, you were not the estate officer.
My lord will see. This order was passed on.
No, not the order. Estate officer has to issue notice.
Yes.
When did he issue the notice? He issued the notice as per section 4. You can't go to section 5 without
Yes.
section 4.
Section 4, my lord.
Now, section 4, who has issued this notice on 6th of August by Rahul the this person. He was not appointed on that particular date. He was appointed on 21st of August 2021,
21st August.
and it was published in the Assam Gazette on 8th of September 2021.
Yes.
So he may have the order passed. He may have the order during the period he could have exercised the powers under section 5. But he didn't have the power to issue this notice. So without the notice, can you go for the section 8 order passed under section 5?
But that is on the record, my lord.
It is there.
Is
See
it?
page 26.
Yes, yes.
It was issued by the managing director. At that point of time, he was not the estate officer. Now let us see the public premises of Homo Economic. You have the act.
Yes.
We also got one.
Yes.
If the estate officer is of the opinion that any person is in unauthorized occupation of any public premises and that he should be evicted, the estate officer shall issue in the manner hereinafter provided a notice in writing calling upon the person concerned to show cause as to why an order of eviction should not be passed. If after considering the cause shown, if any, shown by any person in pursuance to a notice under section 4, and any evidence he may produce, the estate officer is satisfied that. So you have the power under section 5.
Yes.
But you didn't have the power to issue the notice under section 4. Now,
That
without
time-
the section 4 notification, how do you go under section 5? Mr. Sekia, the managing director has been appointed, but he was appointed on 21st of September
September.
2000, on 8th of September 2021. This order was passed on in the month of October 2021. No problem with that. But the passing of an order presupposes of issuance of a notice. But notice has to be issued on the formation of a subjective opinion by the estate officer. Now the estate officer has to form that opinion and then issue the notice. That notice has been issued by the person who was not the estate officer then.
That's what the issues of the record.
So we do one thing, we set aside this. Because your prayer in a suit is that you cannot be evicted without following due process. Due process does not mean a suit. Can be any other proceedings which is permissible under law. So proceedings under the public premises is also permissible.
That be again by the subject matter of this because they have taken that particular plea. That is the public premises is in our. And we are saying that this is a lease agreement, though the courts are mentioning as license, license and licensing. But it is basically a lease agreement. And they have been realizing the rent and lease rent. In fact, a miscellaneous application has been filed recently, yesterday. There also, the realization of the rent your lordship will find lease money. And if in license, it could have been the license fee or whatever, something of that nature. But that has to be decided in the this suit. If the trial court comes to an opinion that the action is under the public premises, etc., it's a different thing. But otherwise, if they hold that this is a pure and simple lease agreement, it will be governed by the lease agreement.
Mr. Secretary, first and foremost, that is a license. Apart from that, apart from the license, another lease and license agreement. That is, be that as it may, let us take into account that it is a lease agreement. But how can there be a lease agreement beyond a particular period without it being registered more than 11 months? Tell me. And your prayer in the suit is not to evict you without due process. This is the due process. They can do so. But why should I go into all these things? I keep it open. I just set aside this because the notice which was issued by a person who was not authorized. So he was not authorized. So the question of the passing of that order, the notice has to be set aside as well as the order which has been passed. On the basis of a notice issued by a person who was not authorized, has also to go. So if I set aside, then it is your next course of action what he does. Let me write it down. In fact, I have very serious doubts on appointment of a managing director as the estate officer. Why so? Because managing director, if he is appointed as the estate officer, you are asking the same person to decide on the same cause. Isn't it? That is why in no other places this is being done. But our government of Assam will do whatever it takes. Yes.
Clause 17 of the agreement is clear, madam. Neither is a tenancy nor a lease agreement.
Well, obviously, this is not. It is a legal license.
Right.
And if the moment he brings it out there in the court, that cannot be taken into account by the court.
Right.
Because it's not a registered document.
Subsequently, it has to be considered as a conflict in network because no formal deed has been.
Monthly tenant means you are depositing in the court now. The rent? Obviously, no. The instant petition has been filed challenging the order dated 7/10/2021 issued by the respondent number 2 with a further prayer that the respondent authorities should not disturb the possession of the petitioner over the Nandanban Resort situated within the campus of ASTC bus station, Jhansi, Sibsagar, during the pendency of title suit number 9/2021 and Mize case number 13/2021. The facts of the case, as could be seen from a perusal of the writ petition and the documents enclosed thereto, is that a deed of agreement was entered into by and between the Assam State Transport Corporation and MS Nandanban Resort on 5th of February 2003. The period of the said agreement was mentioned to be 3 years with effect from 1/1/2003 to 31/12/2006. And the monthly rent to be payable was rupees 10,000 per month, subject to various conditions stipulated therein. On the basis of the said deed of agreement, the petitioner continued to run the continue to use and occupy the land and building described in Schedule A to the said agreement for carrying the business of highway resort at the new building and land of the respondent corporation. It is further seen that even after the period of the said agreement having expired, the relationship between the petitioner as well as the respondent's corporation continued. On 6th of August 2021, a show cause notice was issued by the managing director of the respondent corporation stating inter alia, whereby the petitioner was asked to show cause as to why an order of eviction should not be made. It is, however, relevant to take note of that a perusal of the said communication, said show cause notice nowhere shows that the said show cause notice was issued in pursuance to the provisions of, in terms with the provisions of the Assam Public Premises bracket eviction of unauthorized occupants Act 1971, for short, the Act of 1971. The petitioner, upon receipt of the said show cause notice, submitted a reply on 9/8/2021, stating inter alia that the petitioner is entitled to remain in possession of the premises as he had not violated any of the clauses of the agreement entered into on 5/3/2005 to 2003. It further appears that on 17/8/2021, the petitioner filed a suit before the court of the civil judge Sibsagar against the respondent numbers 1 and 2 herein. Seeking inter alia for a decree declaring that the agreement dated 5/2/2003 entered into by and between the petitioner and the respondent number 1 and 2, bracket the defendants therein, bracket closed, was still existing and as well as in force, semicolon, for a declaration that the petitioner, being in lawful occupation and possession of the scheduled property, the respondent number 1 and 2 herein, bracket the defendants therein, were not entitled to evict the petitioner from the said scheduled property without following the due procedure of law, as well as for permanent injunction. The said suit was registered and numbered as title suit number 9/2021. It further, in the said suit, the petitioner had also filed an injunction application under Order 39, Rule 1 and 2, read with Section 151 of the Code of Civil Procedure, praying inter alia for grant of a temporary injunction restraining the respondent numbers 1 and 2 herein from evicting the petitioner as well as from disturbing the peaceful possession of the petitioner and his men and agents over the scheduled property appended to the application during the pendency of the suit. The said application was registered and numbered as Miss J case number 13/2021. It further reveals from the records that by an order dated 18/8/2021, the learned trial court issued notice. Any injunction? No. This court had also inquired with the learned counsels appearing on behalf of the parties, who also further submitted that no order of injunction till date have been passed in Ms. J case number 13/2021. Be that as it may, on 21st of August 2021, the respondent number 2 issued a communication stating inter alia that the authority of the ASTC had cancelled all the allotment agreement, bracket if any, issued earlier to the petitioner for occupying and running the business of motel resort dhaba named as MS Nandanban Resort Jhansi at ASTC land premises at Jhansi, Sibsagar. Subsequent thereto, on 7th of October 2021, the managing director of the respondent number 1 corporation issued an order under Section 5(1) of the Act of 1971, thereby directing all who may be in occupation of MS Nandanban Resort, bracket Jhansi Resort, ASTC premises Jhansi, to vacate within 30 days from the date of issue of the said order. This order dated 7/10/2021 has been put to challenge in the instant writ petition. This matter was heard at length on yesterday.
Yes, sir.
Was heard at length on 2nd of August 2023, on which date an issue arose as to whether the managing director of the respondent number 1 corporation was appointed as an estate officer in terms with the Act of 1971 and the rules framed therein under. Mr. J. Roy, the learned senior counsel, appearing on behalf of the respondents, sought for an accommodation yesterday to take appropriate instructions in the matter. And accordingly, the matter was listed before this court today. Mr. J. Roy have also produced the learned senior counsel during the have produced a notification dated 21/8/2021 issued by the government of Assam in exercise of the powers under Section 3 of the Act of 1971, whereby the governor was pleased to appoint Sri Rahul Chandra Das, ACS, MD, ASTC, and Deputy Secretary, Transport Department as Estate Officer of the Assam State Transport Corporation to protect the assets, property, land, buildings, public premises, and all other physical/land assets held by the Assam State Transport Corporation in entire state with immediate effect and until further orders. It is further relevant to take note of that the said notification was published in the Assam Gazette on 8th of September 2021. The said notification as well as the Gazette notification dated 21/8/2021 as well as the publication in the Assam Gazette on 8th of September 2021 are collectively kept on record and marked with the letter X. In the backdrop of the above, let this court therefore take into account the provisions of the Act of 1971. Section 2B of the Act of 1971 defines the term estate officer to mean an officer appointed as such by the state government under Section 3 of the Act of 1971. Section 3 of the Act of 1971 being relevant is reproduced hereunder. From the above section, quoted Section 3, it transpires that the state government may, by notification in the official gazette, appoint such person being gazetted officers of the government as it thinks fit to be estate officers for the purpose of the Act, and also define the local limits within which or the categories of the public premises in respect of which each estate officer shall exercise the powers conferred and perform the duties imposed on the estate officer by or under the Act of 1971. Therefore, from the above, it would be seen that it is only after the notification is published in the official gazette notification is published in the official gazette, the appointment of an estate officer a gazetted officer can be appointed as an estate officer. From the documents as enclosed as Annexure X, from the documents as kept on record and marked with the letter X, it would be seen that although the notification was issued on 21st of August 2021, but the said notification was published in the official gazette on 8th of September 2021. And as such, with effect from 8th of September 2021, the Sri Rahul Chandra Das, ACS, MD, ASTC, and Deputy Secretary Transport Department was appointed as the estate officer of the Assam State Transport Corporation. In the backdrop of the above, this court further finds it relevant to take note of that Section 4 of the Act of 1971 stipulates the requirement of issuance of notice to show cause against order of eviction by the estate officer upon forming an opinion that any person is in unauthorized occupation of any public premises. It would further be seen from Section 5 of the Act of 1971 that it is in pursuance to a notice issued under Section 4 of the Act of 1971, any order can be passed in terms with Section 5 of the Act of 1971. In the instant case, in the instant case, a perusal of the order dated 7/10/2021 would show that the respondent number 2, acting as the estate officer, had relied upon the notice dated 6/8/2021 as a notice under Section 4 of the Act of 1971. And it is on the basis thereof have passed the order dated 7/10/2021. However, as could be seen from the observations made herein above, as well as the document kept on record and marked with the letter X, the then managing director of the respondent corporation did not have the authority or jurisdiction to issue the show cause notice under Section 4 as Section 4 of the Act of 1971 as the said officer was not an estate officer within the meaning of Section 2B read with Section 3 of the Act of 1971. In that view of the matter, as the impugned order dated 7/10/2021 is on the basis of in that view of the matter, as a show cause notice issued by an estate officer is a condition precedent for passing an order under Section 5 of the Act of 1971. And the show cause notice so issued in the instant case dated 6/10/2021 is non-est in law, as the same was issued by an authority having no authority or jurisdiction. This court is of the opinion this court is of the opinion that the order dated 7/10/2021 also is without jurisdiction and authority of law. Accordingly, this court therefore sets aside the order dated 7/10/2021. Anything more? With the above, the instant petition stands disposed. Stands allowed, huh?
Liberty given to us to proceed in due course of law. Because
It is, however, made clear that this court have set aside the order passed under the Act of 1971 on the ground of lack of jurisdiction of the authority. No, not necessarily line to line. You do whatever you feel like. I'm not saying anything. You didn't have the jurisdiction, that is it. Because the moment I say this, you'll take it as a handle.
no, otherwise also we issue, my lord.
You issue, do whatever you like. As of now, you don't have a notification for the new managing director.
No, this notification will come into play because now he can issue a note.
Whether that same managing director is there.
Hey, managing director.
Very well, issue it now. I made it clear.
Small, my lord, one sentence, my lord.
What?
To proceed, my lord, as the department, my lord, as ASTC can feel.
The observations made herein above shall not prejudice
Yes.
the respondent corporation to take such action as permissible under law.
Best.
Item 14.
Oh, insurance. Yes, Mr. Gustami, you are waiting for something?
Interim application filed.
Hmm?
This is interim application filed in a pending matter.
Hmm.
After the petitioner received the notice for eviction from a minor stall. Guwahati regulator on the ground that is license period. So we had a little bit of a bitter experience in some matter. They don't give you time with a big loss and go away. So we desperately this was just this application that we filed at the pending matter. Let me make the position clear. The pending matter relates to a very different issue with regard to license fee during COVID period. But there was an interim order from this court saying that no coercive step will be taken. Therefore, friends thought that is a coercive step, therefore interim application is filed. But we may also really file a substantive petition against this order. But will require some provisions of the both 2010 policy and 2017 policy. Only thing, Milord, a temporary protection is needed till that comes up before it.
You belong to which period? Prior to
Because
2007?
It is prior to 2017.
Ah.
And the 2010 policy contemplated a period, a renewal.
Ah.
And 2017 doesn't have a provision for renewal.
Ah.
But there is a clause in the 2017
Ah.
policy, clause 20, subsection 2, the following effect that if the process was finalized under the earlier period before 2017 came into force, then that will be governed by the earlier policy assembly of 2010. In which case there will be the period is 5 years plus 3 years plus 3 years. Therefore, that period will not expire, we get continue. That's the only issue. But that in the main petition, we don't have this basis because that related to a different issue with regard to license fee during the COVID period. And in fact, I am told that your lordship has segregated that case from the other bunch. Because
Ah.
there was a different one.
Oh, that matter, those
Yes.
series matter,
Yes, I.
where I have dismissed it on
Yes,
those.
yes, your lordship. That's what I was told.
Hmm.
So, may I only seek this protection, in this case? We are filing a substantive petition against the order.
Hmm.
And your lordship may just take it up anytime your lordship like, say Monday or Wednesday. And give us protection for the time being, till your lordship take up. Because there is a point with regard to that article or that clause 20 subsection 2. Unfortunately, this was not part of the main writ petition, therefore I am not in a position to state your lordship this case. But I can just hand over the 2017 policy. Your lordship like to have a look.
What is this order passed in another petition 2676? Somebody gave it to me just of Mr. of Brother Manish Chaudhary. What is this?
No, this is for another stall, where there is a similar situation and a interim order was given, I think, no? Just so that there is an interim order in a similar case, because same petition.
So were you finalized prior to the notification?
Prior to 2007. That's what
You
I
were
want to
finalized.
really bring in, because that is not there in the substantive petition, because we have to challenge this notice on that putting on. Therefore, we'll file that petition by Monday. The lordship can have it on Tuesday or Wednesday.
So you are filing, your thing is that you want some breathing space for filing a writ.
Basically. Your lordship can fix the matter, we'll file it on Monday, and your lordship may have it on Tuesday or Wednesday according to your lordship condition.
My lord, so far the writ petition is concerned, the issue before the honorable court in the writ petition was that to give concession that
And that is
for
what
the
I have
COVID
told.
period.
No, that I
Now,
understand.
we have
No.
given, my lord, now, my lord, whether he will get more, my lord, that is to be decided in the writ petition. But for the COVID period, 10 months extension has been given. He availed it, my lord. Now, the order which the sought for, my lord, staying page 14 of the IA application, my lord.
I've seen it.
My lord.
You
Just
have
one
the-
parameter. This is to inform you that the original contract period of your catering stall, Guwahati, at PF number so and so Guwahati Railway Station was completed on 30/9/2022. And the 10 months extended period granted on account of COVID-19 was commenced on 1/10/2022 and going to expire on 31/7/2023. And therefore, he has been directed to vacate the stall. So, my lord, original contract is, my lord, in the writ petition page 13. Original contract dated 10th of May 2018. So 2017 policy. There is no provision for extension also, my lord. Since his original period allowing them extension period over. So therefore, my lord, in my humble submission, there is no illegality with this order, my lord. And this order is not separately challenged also. he has given a, in my humble submission, a separate cause of action, my lord, if at all, because writ petition is so different. And here, my lord, the period along with the extension over. My lord, my lord, there is no illegality committed, my lord, by the authority, asking him to vacate by order dated 1/8/2023, because his entire period over by 31 seconds, including the, my lord, concession
So
period
your
of 10
case
months.
is, his period, his contract was given in the year 2018.
18.
After the coming into effect.
In 2016, it
No.
expired in
Page 39, sir.
So the second agreement, the period of license is from 1/10/2018 to 30/9/2019.
Yes.
Then 1/10/2019 to 30/10/2018.
The original process started the tender notice of 2014.
Yes.
And the order of settlement of this toll with us was given in 2016. So the period is under that 2010 policy, initial period is 5 years, then extension 3 years and 3 years twice. That's the policy.
No, whether there was a process of extension.
No,
No.
there's no prayer also,
Because-
no application.
5 years, then the process was given for all during the COVID period. That
The
in
COVID
that
happened in 2020.
period,
Yes, that period, that is indicated on page 14 of the IML, last para.
so without
Extension
16
period.
to 5 years
Last
is
pyramid-
21. And thereafter, without this extended period.
1/10,
of,
2012.
10 or something, and which expired now.
31.
31.
Have you paid the money?
Yes, yes,
This 3,92,000, 89,000?
license. We have paid our license fee even during the COVID
No,
period.
no, have you paid this amount of 3,89,000?
Yes, that's what I. Yes,
3,89,000 has been paid. You got it? The 3,89,000?
I don't think, Malak, this has been. Nice.
I'm told because I'm instructed to say it is complete. In fact, our money is lying with them. Because we paid in advance. Money is where we took up slab. When I get that COVID period, where there was a sale of closure.
Where is the statement made that the money is lying with them?
No, that is why I'm saying, because it is, I'll have to find a substantive deed. Your lordship can note it because, my. Dealer 89,000 have to pay. We just. If not paid, without we will pay. There is no problem. This is not. Money is lying with them because throughout the period of lockout period, you have paid in advance, but it was not proper. But I am not on that. If they not paid, they pay. Have it on a, we will file by Monday, whatever date. Thank you all.
Mr. Raj, don't do anything till Monday. I'm not passing an interim order. I'm only undertaking your undertaking.
If he has not vacated, I will intimate
No,
that.
no, we have not vacated.
yes.
Yeah, I am before your
Naturally.
lordship, I
No,
am
don't do
vacated.
anything till Tuesday. Let them file it on Monday.
No, this is what has happened because in one of these cases, railway.
Yes.
Court state orally that.
No, I'm recording it. He's undertaking. That he won't, he will inform the authorities not to evict
Yes,
you,
that's all.
to maintain the status quo
Correct.
till Monday.
Absolutely. That is a good.
Because why I'm not passing an interim order, Mr. Gupta, there's a
Yes.
problem.
Yes, the period already open. My lord will record my submission. On the basis that page 14 I have made, my lord.
No, you say, but you
My
say
submission
that,
Right.
as this is only he's buying a breathing time
Yes.
for the purpose of filing the writ petition.
Sure.
So don't do for next till Monday,
Monday.
till 8. Don't do, maintain a status quo till 8.
Milord,
Thereafter,
Yeah.
I'm not This is your undertaking. Why I'm saying about an undertaking is because if I pass an order, then it can be extended. Undertaking can't be extended.
Right.
That is-
I'll intimate.
May I only say this? We'll file it on Monday. It may not come before your lordship on Monday, so I have it on Tuesday or Wednesday, whatever. is the lordship.
I'll have it, therefore I'm asking him to maintain a, yeah. You
If
can
are-
in fact ask your junior to mention the matter tomorrow, I'll take it up. I have no problem. I always give permission to everybody.
Yes, that is right. But
Today, this matter, while I was rising at 3 o'clock, these people asked me whether this is, you'll take it up. Because this matter was there in court number 3.
Yes, yes.
So it was in court number 3. So they asked me,
Yes.
so I said, okay, no problem.
may I say that we'll file it by Monday?
File and ask for urgent taking up.
But your lordship,
The instant application has been filed. Interlocutory application has been filed. Seeking a stay to the order dated 1/8/2023 issued by the Senior Divisional Commercial Manager, NF Railway Lumding, dated whereby the petitioner has been asked to vacate the stalls by 1/8/2023 after clearance of the due license fee of the extended period and the interest of rupees 3,89,392 and other dues, that is fine, oblique penalty, oblique interest, comma, water charge, comma, electricity bill, etc., if any. This was in the said order, it has also been mentioned that the pending license fee against the period of the 5th year and the interest, if any, is to be deposited by the petitioner according to the final verdict of this court against WPC number 6204/2021. Mr. B.K. Das, appearing on behalf of the respondent railway, submits that the instant application is not, has no connection whatsoever with the original writ petition which has been filed. Mr. P.K. Goswami, the learned senior counsel, submits that this court may provide some protection so that the petitioner can file a substantive writ petition by Monday. Mr. Bikeda submits that he would ask the respondent authority to maintain status quo. As regards the stalls of the petitioner, in terms with the order dated 1/8/2023 till 8th of August 2023. Taking into account the above, this court directs this listing of this matter on 8th of August 2023. The undertakings were given by Mr. P.K. Das. Now, this court further duly takes note of the undertaking given by Mr. P.K. Das, the learned standing counsel for the railways.
My lord, so far as my lord, the status quo, that my lord, no coercive action, that will be, my lord,
That- No,
no coercive action, my lord.
status quo,
Status quo, my lord, that will be problem, my lord, that time.
that is being brief. You are not
My lord,
asked for any vacating of that.
in my humble submission, my lord, not to take coercive action till Monday, my lord. That may be better, my lord.
Shall not take course.
Yes.
Why I'm saying status quo is, it is, you have already evicted him, then it remains.
No.
If it is not, but status quo shall be maintained. As of today. Okay, you want no coercive measures?
No coercive.
Extremely fine for
That is the order there. Obligation. I will.
shall not take any
Coercive.
submit duly submit and that the response that you will instruct the respondent authorities, respondent railway authority, that no coercive action to be taken till 8th of August 2000.
Obligation.
It will duly after this court therefore duly takes note of the undertaking given by Mr. Piketa and as such have not passed any orders.
Obligation.
But you say that, it will be some up on the paper.
I can't pass. If you have not filed, how can I? do it?
You-
14.
Mr. Goswami, you can ask your junior to mention the matter on that date, on 8th or 7th.
I have asked them to see if you can find it by tomorrow.
Tomorrow also, if it can be filed, make a mention tomorrow. Provided it belongs to this page. Yes,
Your Lordship, as per Gurmeet Singh case, I have made the calculation. As on date, they are entitled to 8,87,393 along with interest.
see, there are two courses of action. While I thought about it. One is setting aside the order of the Lok Adalot. The moment the order of set aside, the appeal revives. If the appeal revives, you don't know when it will be disposed. So your interest is not carried. The second is, you agree to make the payment of this amount which you have come and finish it off. That way you will prove it. Take an instruction on that. Because that is, I think, more reasonable. Because if you see Justice Bhuya's order here, if you see this order, the insurance company has filed this appeal challenging the legality and validity of the judgment and order dated so and so, awarding compensation of so and so. Mr. So and so, the journalist submits that an amount of rupees has been. On proper instructions, he submits that in the spirit of Lok Adalat, insurance company is willing to withdraw the appeal. If you withdraw the appeal, then where is the question of no interest? That's the point. So what this court is, there are two options. Either you have to set aside this order being not in conformity and then bringing that appeal, or this may be a case where this court can interpret what the court had stated and then direct you to make the payment, or you make the payment. These are the three options. Take your instructions. We'll have it next week. Huh? List the matter on how much? 9th? Possible?
9th.
And we'll have it on 11th. List the matter on 11th of August 2023. On which date the learned counsel appearing on behalf of the respondent insurance company shall take appropriate instructions in the matter.
Obligation.
Yes, Mr. Six, your matter. Item 1, 2, 3, your matter.
1 to 3.
This top of the list item was before some other judge. And now it has been put to me. Eh?
No, but it is running from two.
What?
Peace scheme. Not a peace scheme. It is a 16 matter.
What is this review petition? Let's see. Appearing on the
Your lordship will turn to page 33 now.
Then what is this writ appeal file
Well,
against
that-
that order?
No, my lord, now your lordship, page 33. Page 33, what are your lordship has seen? Page 30.
Yes.
My lord, page 33 order. Here is, it is.
Show me that
specifically-
earlier order has been reviewed.
That order has been issued.
So as of now, you don't have an order.
No, my lord. What happened, my lord? Against that, I have filed a writ appeal.
That writ appeal says that all these grounds can be taken.
Taken
But as of now, do you have an order?
that order. That
Yes.
earlier order, that is.
Yes, you have an order.
My lord.
You see, your entire case,
My lord.
as of now, Mr. Sheikh, you are aware that after 2011, although the Supreme Court judgment is always deemed to be a law which has been existing since from the day the Supreme Court came into existence. But if a finality is arrived at prior to the Supreme Court's order, you can't reopen on the basis of the Supreme Court order. The law is settled. I'm not on that. But do you have an order to that effect? You don't have that order. That order is already reviewed. See the point?
Order is reviewed, my lord. Your lordship would be pleased to see that.
So I have to now decide,
Place my case.
understood, but Mr.
I
But
have to
Mr.
place-
Sheikh, kindly appreciate.
Okay.
I am going to take up this writ petition
Madam.
with a clean slate as to whether there can be a direction to give a lot.
Madam.
By keeping a completely blind eye on the order of 16/7/2009.
That order is not there.
So under such circumstances, can this court today, in view of this Jakpal Singh, pass this order? Matter ends.
No, let, when I go for appeal. When I go for appeal. Against.
Appeal, you made the mistake.
Your
Why did you
Your
leave
lordship
that appeal
would
so
be- would be pleased. to
easily?
see- would be pleased to see
I've
what
seen
is the
it.
Order passed in the.
I've seen the appellate order, just now I've
appellate
seen it.
order.
It says
Well,
that all these pleas, you can raise it before
well,
the single judge.
Right.
Very well. The appellate court, the division bench say that all these pleas you can raise, but how can you raise that plea when you don't have that order of 16/7?
well, Lord, your lordship would be pleased to consider this writ appeal order.
That is what I'm seeing.
Every point I can take before your lordship.
Mr. Sheikh, kindly see. Considering the fact, learned counsel for the appellant contends that the appeal may be disposed of with the liberty to the appellant to take all these pleas before the writ court.
My lord, now,
We
now you-
allow the writ appeal to be disposed of with liberty to the appellant to take the plea before the writ court.
now your lordship, what was the plea in the writ appeal?
Hmm.
Plea in the writ appeal is this, my lord. After long years, after my lord review petition was filed. A review petition was filed in the year
Yes, Mr. Bhattakar, you are there?
18, my lord. 2018,
For what?
No controversy.
Why?
That order was indically. In his mind. I think. That order. On going to take the order and rather. Order. And keeping in mind that was the 10/9/1995. But sometimes even after. Again, trying to fix that.
You are in which, what land?
Stay over. Easier.
How can there be allotment?
That ultimately. Cannot be made, that. Taken by the.
No, there might be another. Why don't you make us okay? The allotment can maybe not made there. There's no worry. But taking into account the land policy, why not in some other way? Because you see, in view of the Supreme Court judgment, there's no way the allotment can be made. That one can't give it. Whatever the division bench may say or different things. The Supreme Court order is very clear in Takpal saying that this community land cannot be given for allotment. And as such, the allotment which were given out there in Takpal Singh, were all set up. That is why that day I was, as I was telling you that matter, I was say Rule 18. You see, Rule 18 initially grazing grounds, roadside reservation. These are the lands which cannot be given for settlement. And as such, Rule 18 only permitted dealt in 1996. 97, they bring in the host of things. Even a private property belonging to anybody can be thrown out by the circle officer or the deputy commissioner saying that you don't have right over the land. So Rule 18, as it stands after 97, has become the, if nothing is not done, you'll have a severe consequence. There's no notice. The difference is today, the concept of notice is foreign. But how do you take care that the settlement can be made in respect to wasteland? You can settle only wastelands. If you can settle wastelands, then if it is that land can be settled, then why are you required to throw them out? And then you see settlement, I think regulation 34 or 40, that you have to offer the settlement to those persons who are in possession. Now, does the settlement rule 16 override this 40 or 34? No.
Another thing is there, that regarding this Rule 18, Rule 5 is there, 6 is there, settlement rule. That is not amended. That is not amended, that the person concerned, you can file an application, deputy commissioner will survey the land and give a decision on this application. That is not amended.
Understood, but that is for wasteland.
Yes,
The settlement can be made only in respect to wasteland.
yes. There is no.
So therefore, your applications which are there has to be construed as applications not for that land, but for some other land,
Maybe,
being landless.
maybe.
May not be, they may not be getting that BGR. But other lands too, you can.
That particular land may not be. Now your lordship, may I please before your lordship?
Because take your case is, means what the division
Now-
bench has done
now
to
my
you
What
is
reason was said,
after
Lord,
not
I can
interfering
take-
with the
I can
order of
take all the
16
point.
May.
Now your lordship would be pleased to see, review petition was filed on 2018, after 9 years. After 9 years. In 1964 Supreme Court decision, my lord,
Mm.
3 years is the limitation. Now what happened, my lord? Everything has been done. And in 2018, after 9 years of the order, they filed the review petition. And the honorable court, my lord, allowed the review petition in pursuance of Jaspal Singh, my lord, in 2012, 2011. Now I approached the division bench, my lord, and division bench said that every point you can raise. Every point I can raise, my lord.
For what? How
Why
can
have
you
to
raise
petition
now
before
the
your lordship?
point that I had an order which is no longer there?
My lord, no, my lord, that is my writ appeal, my lord, that is my writ appeal. That how review can be done after 9 years. So that point,
Your
Now-
settlement
now-
application is pending.
my lord,
Your settlement application is pending.
my lord, regarding that,
Yes,
my
Mr.
lord,
Dotto, what have you done to his settlement
I
application?
am taking a few minutes from your lordship.
No, it's okay. Mr. Dotto,
Your-
what have you
your
done to his
lordship.
settlement application?
Perhaps no application there.
Yes, he may not get in the BGR land, no problem, you throw him out. But you give him some other place. They've been all along out there, they have filed a settlement application. Yesterday I passed an order, Mr. Sheikh.
Now, my lord, now your
There
lordship.
was an application filed in
Regarding
the
this,
year
my lord.
1995.
Yes.
Yesterday I passed an order.
Yes.
There was an application filed in the year 1995. There was a land advisory recommendation also given
my lord.
in respect to a land out there, just in front of the capital. But these people were not taking note of, and I passed an order that they have a legitimate expectation for consideration of that application. Now, in view of the present land policy, this is village land,
Is there?
village land.
Yes, that's it.
So what is the amount of land one gets out there for the new policy of 2019?
1 big hand.
1 big.
Okay.
So why can't this petitioner's application be considered for other lands? You don't give him that, but consider the
Some other-
application for other lands. Consider it, because you have a policy.
That's it.
It is not that, and if the petitioners are otherwise eligible as per landless
Right,
variant.
right.
give it.
Prerogative people
I think
will-
that is the best order you can get, Mr.
My lord,
Eh?
my lord. Because, my lord, we
But
are. landless.
VGRL, I can't give it to you.
My lord, that order will.
That can be passed. Provided they have to file a application. They have not filed any application.
No, my lord, that is a wrong submission. I am placing before your lordship. Your lordship will test 38 of my petition. How the matter progress, my lord. Your lordship will turn to page 38.
No, Mr. Dutta, you see, if you want them to file application, they will file. But don't evict them till they decide.
Yeah.
Or would you consider their earlier application? I think that is the better option. You have their application if it is. I'll take it up on next Monday.
Tuesday.
Next Monday.
Tuesday. Hearing.
Why? Tuesday, I've got a lot of matters out there.
Tuesday.
These are not matters for these. These are small matters.
That's it.
You take your, I'll give it on Wednesday. Take it your instructions on the basis that would you like a fresh application? Or, and the land policy, Mr. Kotaku, you just point out the land policy. Now that land policy, when you have applied it on the thing, and on the basis of that land policy, you take a decision. And allot, and you have a land policy to allot, do it, allot them or whatever may be, until then, without intimating the fate of their application, you can't intimate it. Okay. That is the order which I took.
That can be passed.
Because VGR land,
But that's right.
Matter has been heard at length, leaves the matter on 9th of August 2023, on which date Mr. S. Dr. the Learned Standing Counsel for the Revenue shall take appropriate instruction as to whether the petitioner's application for settlement will be considered in respect of other lands, other wastelands of the.
Lord, may I pray that it may make part of it.
What that is,
Otherwise.
it will come before me. Till I am taking bench 5, it will come before me. Land allotment is mine. And no, this top of the list, no, this will come.
My lord, it may be kept part, otherwise, my lord, in the top of the list also sometimes this happens. So my humble submission before your lordship, as your lordship
No,
pointed out something, my lord,
Mr.
and we agreed to
Mr.
that.
Sheikh, didn't you see all these matters which I had taken up? Yesterday, these matters were heard. And as such, I disposed it. Your matter will also be disposed of online.
My lord, my assessment is this one.
Yes.
My thinking is this one. Court is rolling. Tomorrow, my lord, this case may go to some other honorable judge. And that honorable judge may take another view, my lord. And we are fighting this matter from 2012. my lord.
The other honorable judge may give you a benefit. I am not, I am
No,
saying that.
My humble
67
submission
is
before
not
your
there.
lordship, it may be kept part.
No, not that. It is not required. It will come. I've said the matter has been heard at length. Likewise, that is enough. No judge will.
Keep it part.
No.
But otherwise, my lord, there may be something.
I don't keep any matter part heard. These people, the registry has put the part heard in the other matter. I am not part and order for part heard. They don't write any part heard.
Yes, man. Oblige your lordship.
Part heard CAV is nothing.
Item number 6.
Yes, Mr. Pegu, what is this matter about?
The petitioner was dismissed from service.
And the allegation is that the petitioner was in a drunken condition, abused the senior colleagues.
When he was dismissed?
2008.
Huh?
I was dismissed from service in the year
Then?
2003 without any inquiry. Thereafter, I prepared a repetition at page 35.
Then
That was set aside. And
there was an inquiry.
my,
Then
then my lord, charges were framed and subsequently my lord, the order of dismissal was upheld. Thereafter, I prepared a appeal. That was also was against me, and thereafter I prepared a revision petition against me. That was also.
what is your ground? Are you getting pension or not?
My lord, may kindly come to page 39.
Why? No. Tell me what is your ground? Well, I admit that without inquiry, they threw you off.
Yes,
You filed a writ.
Yes.
The writ was allowed. So they had an inquiry proceedings.
my lord, only the thing is that my lord, at page 39, the learned single judge directed them to confer all the consequential benefit to the petitioner for. That means my lord, from 2003 to 2008, I was entitled for that. Now my lord, may kindly come to page 40. I was reinstated in terms of this order. But my lord, at page 41, without fulfilling the sale order at page 41, my lord, in view of the petitioner is reinstated in service and directed to report within 15 days. My lord. Subsequently, my lord, the petitioner in his reports to the unit will be.
In view of the petitioner is reinstated in service and directed to report a square code within 15 days. failing which the order of being statement will itself be treated as contrary. The petitioner in case report to the unit will be deemed to have been based on the suspension in the date of suspension till the finalization of the departmental proceedings which will be brought place against him. Yeah, then
Dismissal order was set aside. That has not been challenged by the department. In spite of that, my lord, this order was passed and directing me for suspension from the date of dismissal. It is from 2003. But that was set aside. Now thereafter, I prepared a,
this order has been also set aside.
no,
So this order remains.
this order remains.
Then
Now subsequently, my lord, at page 44, the
Hmm.
charges per payment that was handed over to me.
Hmm,
At page 45, 3 charges per payment.
hmm. Then
The charges were, my lord. I was posted at the main gate on 1st of July 2003. And thereafter, I left the duty at about 13:15 without any intimation or permission from the competent authority and arrived at,
makes the council tell me what is wrong with it.
my lord, my case was not. considered.
You
There
see,
is
this court, first of all, you have to arrive. This court is not the appellate authority.
My lord,
We are only going to see if it is arbitrary, unreasonable, and have occasioned manifest injustice,
my lord.
as well as perverse. Now, during the inquiry, you were given a charge memo.
Hello.
You replied.
Right.
Inquiry officer was appointed.
Right.
Presenting officer was appointed.
Right.
So that formality is done. Did he give evidence? No, they don't.
They prepared.
They gave evidence.
Yes.
You were given a right to cross-examine.
Right.
You cross-examine.
Right.
Did you give evidence? So that is there. So there is nothing on the procedure.
Right.
Procedure is okay. Now comes to the order. Charges, how many charges were there?
3,
How many charges were proved?
all the.
What are the charges proved?
My lord, I left the duty without, my lord, intimation or permission under the influence of liquor.
Next,
Secondly, my lord, I deliberately fired 4 rounds of bullet.
and third,
And my lord, third, my lord, that 4 bullets that tantamount to loss of government property.
so 2 and 3, let us not clear, but the first is the most important charge. That you were drunken and left unauthorized.
Right.
You are in a discipline service?
CISF.
What is that?
Uh,
Police,
security.
security? So it's a discipline service. Now, are you on the proportionality?
Yes.
As per you, what should have been the punishment?
My lord, was the liquid, there is no medical evidence on record that I was under influence of liquid.
Oh.
There was nothing. I didn't have that. My written statement showed that. Subsequently, they were only out the cross-examination as well as the statement only showed that they thought that I was under the influence of liquid.
They thought,
Yes,
not on the basis of they said,
no,
let us see that. So you are on the perversity.
man,
Tell me where. Where is the evidence? PW1 is not an eyewitness and all evidence are based on false analysis. What is this? Departmental inspector. Yes, PW1, what did he say? This witness is not an eyewitness, all his evidence are based on. Where's the inquiry report?
inquiry report, my lord, that was in particular that has not been enclosed. I have that type.
Oh, okay.
Now,
Okay, what did he say is here, na? Oh, you are saying this.
these are, I am saying, my lord, I have submitted. These are my statements and based on that, a GD and.
Let me see his evidence. Show me the evidence of that inquiry officer. Of that is PW1, 2, who has said that you were drunken?
My lord, all the 4%.
All four said,
Yes, sir.
but they were not eyewitness.
PW one came after he was intimated. He was the senior person.
He didn't meet you,
No,
so he had no connection.
nothing.
Now,
He
did
was
you cross-examine him?
My lord,
Did you cross-examine him?
no,
You didn't cross-examine.
no.
Then, number two,
Then number two is the complainant against whom the complaint charges has been filed that I deliberately fired upon.
you fired a round against a person.
That is the allegation.
Then what did he say? Did he give evidence?
Yes, sir.
Did he say that you were drunken?
Yes, sir.
Was he a person with whom you had the encounter? Did you meet him?
Yes, sir. He was the PW2.
What did he say?
During his cross-examination, my lord, he admitted that my relationship with him was normal. But when at 1 p.m. I had to report. And at that time, he thought that he got the smell of liquor from me. I need to put on my signature at the register so that I can carry out my work from 1 p.m. to 5 p.m. He did not object. There is nothing on record to show that he has raised any objection. He allowed me. I attended at 1 p.m. and then 1:15 that incident occurred. 15 minutes back.
15 minutes later, you fired
Yeah, the allegation.
4 rounds.
But the cartridge, they only got one.
Huh?
Once I fired the bullet, one cell remained. They only got one. The remaining 3, there is nothing. Wait to 3 gone. There is nothing on record. Secondly, the gun, that was an automatic gun. So if I trigger it, all round 90 days at one time, 90 bullets at one go, it will go. But their allegation is 4, that I deliberately shot 4.
So did you cross-examine him?
Yes.
What did he say?
Now, this was regarding the bullet and all that, those were not his record. His findings came up after the police. Because at 1:15, the incident came up, at 3:30, DD entry was recorded, and at 8:45, after 5 hours, I was handed over to the police. Then police make up and search the location, they found one. That's it. Now, the appellant of there is no discussion about all these things by the inquiry.
Where is the inquiry report? Mr. Counsel, unless you show me any perversity, how can this court interfere with this? Because charge number 1 is proved on the basis of the evidence of SDB and RK Agnihotri. Agnihotri says that at that point of time he was not there, but when he went out there to meet you, you were sleeping out there after being drunk and you couldn't talk.
But my lord, there
You have on the other hand alleged that those 3 persons were under the influence of liquor, but which could not, you couldn't prove. There was no evidence.
there is no evidence that I was under alcohol. Neither there is nothing on record to show that either of any of the parties were.
The counsel will let us not go into a criminal trial. Criminal trial, okay, the evidence as regards get a breath analyzer and all these things will be taken note.
No, and based on
But
the,
here, where's the question? Did you ask for anything in your cross? You didn't examine the cross of PW1.
based on the FIR.
PW1 categorically says out here that, look here, I was not there at that point of time, but I came out there and found I wanted to talk to him. He couldn't because he was dead drunk and he couldn't even speak. If that be so, why haven't you cross-examined him? These statements could have not been tested. You have not given evidence. What happened to the police? What did they find?
Nothing, just the,
What did the police do? Yes, Mr. Pegu. What did the police do?
based on the FIR registered, my lord,
That I'm not aware of the status, my lord, but he was handed over.
Don't
to
tell
police.
me you are not aware of a status of a matter which where the person has already died in 2008.
a section trial was initiated against me based on the FIR, my lord, that has acquitted. All that.
Acquitted on what ground?
No, the evidence, my lord, there is nothing. Those were the statements made by those witnesses, my lord, those were found to be perfect. And exactly, my lord, the written statement that I had filed in the year 2009. Furthermore, that finding has been recorded by the trial court in the year 2010.
How did the appellate court take note of it? Office of the Senior Commandant. Who is this?
Page 100.
What is page 78? Oh, here he has taken note. The detail order.
Page 78 is the dismissal.
The
order.
disciplinary authority has taken leave in it. Qualification. Suspension. Anything. What happened to the appeal?
That has been rejected.
How?
Page 100.
Hello, we'll hear it some other day. It's the matter for hearing again on 10th of August. But Mr. Council, not satisfied till now. You have been given everything. This board very difficult. Very difficult. Yes, Mr. Chaudhary, what are you doing here? Okay.
Nine.
What is that? Nine.
Textile Corporation.
What is this matter? Huh?
It is a appeal, my lord, the petition filed by the Assam State Textile Corporation
Hmm.
against an order of my lord passed by the my lord Labour Court here. But my prayer today would be, can this matter be taken up on 31st of August, my lord? I have a consent of the other side, Mr. Tasit here. Including these days, my lord, in the international, I have some personal difficulties.
When do you want?
31st of August, my lord.
At the request of the parties, matter stands adjourned till 31st of August.
Quickly, obliged.
What is it? Yes,
I've got the instruction. Well, look, the petitioner has got a detachment from his service much earlier. Lord. The matter is in separate.
item number 5.
Yes.
Mr. S. Ali,
Lord.
Mr. The learned counsel for the petitioner submits that the petitioner,
Robin Chandra Tata.
no, he has retired.
Yes, sir.
He has retired from service when
Much earlier, Lord.
submits that the instant writ petition has become infructuous. And as such, the petitioner would not like to press the instant writ petition. Taking into account the above, the instant petition therefore stands closed as it has been as it had become infructuous.
Okay.
Yes. Yes,
Doctor, in this case, matter become infructuous. This matter also become infructuous.
your name?
M. Mohan Prabhu. Partner
No.
also retired. Partner also retired.
The learned counsel order to same. Infructuous.
Retired on 31st of 31.
The learned counsel, Mr. M. Mohanta submits that the petitioner had retired on 31st of
May
May
2015.
2015. And as such, the writ petition has become infructuous.
Particular without a penalty. Coming up to without a penalty.
No, had retired on 31st of May 2023
And
and
penalty was
2015.
imposed.
And the penalty so imposed upon the petitioner have also been withdrawn
8/7/2015.
on 8/7/2015. As such, the instant writ petition has become infructuous. Taking into account the state statement, the instant writ petition stands closed as infructuous. Anybody 8? What is that?
I asked it up to 7,600. Lordship may kindly fix the date.
When?
Lordship next week.
Not next week. Next week not possible. Too many months.
Lordship after the meeting.
Have it on 22nd.
Lordship 21st.
21st, Monday. Not possible. Monday, how can you finish up this?
22nd.
It's the matter on 22nd of August 2023. As prayed for by the council.